All right. President, the judges, European Court of Justice.
Caribbean Court of Justice, original jurisdiction, hearing of the matter DMOJ2022, the DCP Successors Limited, and the State of Jamaica. Members of the hearing panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Witt, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Barrow, the Honorable Mr. Justice Burgess, and the Honorable Mr. Justice Jamida. Counsel, you may now enter.
Thank you, Your Honor. The representation of claimant remains as it was yesterday. I appear along with Sundiata Gibbs and Timerimus.
Your Honor, the representation for the defendant remains the same. I appear with Ms. Cherise Gale, instructed by the Director of State Proceedings for the Attorney General of Jamaica.
Yes, thank you. Good morning again. Good morning, Counsel. Mr. Hilton, are you ready? I'm sorry to keep neglecting CARICOM. I take it that the appearances are as yesterday. I'm sorry about that.
That is so, Mr. President. I feel no neglect at all. I am firmly fixed on who the parties are. We are here to be helpful to the court.
Yes. Thank you.
Your Honors, this morning we filed a chronology, which I hope the court will find helpful and that may also shorten our oral presentation. I must start, however, Your Honors, by apologizing and asking to make 3 corrections. On page 3083, and I'm going to be using the electronic pagination. At page 3083, the entry at 2017, it says DCPS buys Colgate-Palmolive's business and plant. The evidence was actually that they bought the plant. So I think that for full accuracy, we should delete the words business and. Secondly, on page 3086, the first entry may I continue, President?
Yes, please.
The first entry at the top of the page, there's a timestamp that says 5/21/30. It should be 5/23/12.
5/23?
12, Your Honor. 2, 5/23/21.
Page 3093. 5/23.
3086.
To 5.
3086 should be 5/23/12 to 5/23/21.
Sorry.
And then on page 3088, at the September 22 entry, the second paragraph says DCPS evidence is that it has supplied product to companies in 4 other regional territories. It's 3, but the word other, of course, excludes Jamaica.
Yes.
Thank you. Your Honors, given that the parties filed separate statements of facts, Your Honors will have appreciated that they do not agree on all the relevant facts. But some facts are not in dispute. Those are: the claimant is an entity in a CARICOM member state that manufactures soap and soap noodles. Secondly, soap noodles imported from outside the region attract a common external tariff of 40%. Third, throughout the relevant period and continuing today, some Jamaican producers, soap producers, have been importing soap noodles from outside of the region. Fourth, Jamaica does not apply the CET on the extra regional soap noodles. Prior to 2020, this was because of a misclassification of the tariff heading that is applicable. And since 2020, this has been done on other bases, including reliance on local legislation, the product input relief regime. And finally, Jamaica issued certificates of origin to soap producers who should not have received them. It stopped issuing those certificates in June of 2021. So I start by saying that those facts are not in dispute. In relation to the issues, and now I would ask Your Honors to go to the yellow bundle, bundle 1. Our statement of issues, the claimants, at pages 2994 Did I say bundle 1? I'm sorry. Yes, correct. Pages 2994 and 2995. We identify two main issues. And that's, of course, whether Jamaica breached Article 82 by reason of not applying the CET, and whether it breached Article 84 by reason of issuing certificates of origin, when it shouldn't have. And we have a number of sub-issues. The defendant's statement of issues identify the same issues, although worded differently, but they add two more. And if Your Honors turn to pages 3001 and 3002, at items 6 and 7, those are really two separate issues, or two additional issues. Whether the claimant had proved this ability to satisfy the quantity and quality requirements, and whether, in the light of concerns with the quality of the claimant's soap noodles, the claimant has shown that it was deprived of benefits under Article 82. What we propose to do, Your Honor, subject to the court having a different preference, if we go back to 2995, our breakdown of issues, I propose to address, Your Honors, on issues A, B, E, and F. I would then ask Mr. Gibbs to address, Your Honors, on issues C and D, that is the alternate arguments, and on the issue relating to Article 84. And to the extent that time permits, I will return to address you on those last two issues that the defendants raised in relation to deprivation of benefits and capacity.
Mr. Hilton, good morning. In their defense, the defendant raises the issue of good faith. How does that relate to the list of issues you have given us?
I'm actually about to say,
yes,
Your Honor, that issue, that defense pervades their issues.
yes.
And I will address it first.
Okay.
And you'll what?
I will address it first.
Okay.
because the first issue is the Article 82 CET issue. And there are two relevant time periods. Prior to 2019, when Jamaica decided to stop the misclassification, and post. In their statement of facts and issues at 3001, paragraph 1, the defendants sets out their formulation of the first issue, that is a pre-2019. And it's the same as ours, except that they add the words in the last two lines, based on the available information and technical analysis conducted at that time. And those words are effectively the precursor, the introduction to this good faith argument that they make. And effectively their defense on this and other issues is, we did the wrong thing, but we did so in good faith. This good faith defense pervades the defendants' submissions on many of the issues, and it also pervades their witness statements. And our response is twofold. As a matter of law, it is not a good defense, and as a matter of fact, it is not supported by the evidence. We will submit that the evidence shows that throughout the relevant period, the defendant has consistently and deliberately sought to avoid imposing the CET. They failed to consult appropriately with the relevant regional and international bodies. And when they did communicate with them, they sometimes conveyed incorrect
They
information.
sometimes what?
Conveyed incorrect information. And for a long time, they did not consult or even communicate with the claimant. Your Honors, Bundle 3 sets out our written submissions. And I will, of course, not read them, but there are some paragraphs that I would refer to. Those submissions start at 1489. At 1495, we have a general commentary regarding the CET, citing the relevant article. And if Your Honors go to paragraph 30, on page 1497, we quote the court's judgment in the state of Belize in relation to the importance of the CET, and make the points in 31 and 32 that a difficulty that the claimant faced in that case, a dispute as to whether the state had been imposing CET or not. It's not an issue in this case. The facts, as I said at the start, as to what's been done and not done are established. Jamaica argues that the misclassification pre-2019 followed and was based on technical analysis and was done in good faith. And they actually used the phrase, they conducted comprehensive technical analysis and research. Your Honors, the only evidence of any kind of analysis or research is a report from the Bureau of Standards. There's no evidence of any other technical, apart from the statements made. And that document, and I'll just tell you, Your Honors, the reference, I don't plan to take it to it unless you ask me to, is at bundle B4B, page 2966. There are two striking things.
But Mr. Hilton, just give us a date. You don't need to take this, but you could give us a date for the record.
It is September 2019. Your Honors, I can. September 9, 2019. And indeed, Your Honor, I'm glad you asked that, because I was about to say that there are two striking things about the report.
Just to clarify, in your chronology, these are all cross-reference, right?
It is, Your Honor.
So we can easily pick up the details there.
Yes, in fact, Your Honor, when Her Honor asked me the question, that's where I looked. So I've actually found the chronology to be quite useful as a reference point as well. I was saying that there are two striking things about that report for present purposes. One is the date. It was done in 2019. And that means it can't have been the basis for the misclassification that took place for the years prior. It was done at a time, indeed a year after the claimant complained, and indeed after the matter had been taken to the court by Dominica. The other striking thing is that the report does not suggest that 38.23 was the correct tariff heading. In fact, it specifically says it's not. So that technical conclusion from research cannot assist the claimant, cannot be a justification for the misclassification. Jamaica says in their submissions that this shows it was a highly technical process and a difficult matter, because this report also does not conclude that 3401 is the correct tariff heading. But what they should have done, given these difficulties and these apparent uncertainties, is consult with CARICOM and seek guidance from a CARICOM body.
So this report is a report generated by an authority in Jamaica?
It is, Your Honor.
Okay. And you are saying that it was generated and produced at a point where it could not have been the justification for the classification which preceded it?
Exactly.
Okay. So are you saying then that if the report had been generated at a time when Jamaica could have relied on it, and where the report had also given the, is it chapter heading 34? 1.
I'm sorry, could you repeat, Your Honor?
No, I'm just wondering whether if the report had given the information Jamaica sought to rely on, whether that would have been a good defense based on a good faith argument.
I would say, Your Honor, it would not, because they ought, if we step back to consider what was the issue.
Yes.
The issue was, what is the correct classification for the purposes of their obligations under the treaty?
Exactly.
The appropriate place to go for guidance would be a CARICOM body. Can't be to a local internal body.
So, in other words, the advocacy you have given us thus far is, in a sense, not decisive of the issue, because whether whatever the date of the report and whatever it said would have been a product of the local Jamaican organization. Yeah?
That's correct.
Okay.
And to some extent, I am doing this because I'm also addressing the good faith issue.
You're also addressing
The good faith issue.
Oh.
Yes, but that's my point. That even if they had relied on it in good faith, and it was available for them to rely on, the question is whether good faith is a defense in international law. So what I'm trying to get at is the nature of the liability that Jamaica was under once it had undertaken to abide by the terms of the RTC. I'm just wondering whether that features in your...
To some extent, Your Honor, I'm using the court's time, perhaps not well.
Hold on. Sorry. In addition to the question asked by my brother, is it your submission, as I thought I apprehended, that good faith requires that you consult not just with local bodies, but with the regional bodies? So good faith requires not a consultation to say that I have consulted, but it requires appropriate consultation.
Yes, Your Honor, absolutely. And I'll add to that, Your Honor, it also requires a consultation with the affected parties.
Okay.
And in this case, and I'll come to this further, the lack of communication and consultation with DCPS was significant and was also, I think, constitutes a breach.
Mr. Hilton, before we move, I just want to be clear for my own note. I don't think you use this language, so it is my language, but just tell me if this is what you're saying. You say they should have consulted with CARICOM. Is that because you are saying that CARICOM would be the regional classification authority in relation to this issue?
Yes,
So you say,
that
I'm
is
just
the-
trying to put a description to the question, why should they have consulted with CARICOM as an authority? So my language is because I think you are saying that they are the regional classification authority for the purposes of the RTC and tariffs.
That is what I'm saying, Your Honor. Your Honor put it better than I did.
No, I'm understanding what you're saying. I just want to be clear that I understand what you're saying.
Your Honor, I'm not sure what is the protocol, but I trust I can sip from time to time.
As long as the president doesn't disallow, then that's fine.
I did it quickly before he said anything.
Yes.
Your Honor, I'll just add one more thing. And that is that this is in circumstances where Ms. Davis, the senior witness for the government here, confirmed that in her view, Court's decisions are binding on member states. So she recognized and accepts that in terms of Justice Jamadar's question, that there is a regional body that is makes decisions binding on member states. And so what you could have gotten is not just guidance in the sense of something that you could follow or not, but you could have gotten a binding position. All the more reason and need to consult. And if I could just ask Your Honors to note that she says this at timestamp 5/28/33 to 5/28/37. Your Honors,
Mr. Hilton, before you go on, I'm looking at your chronology. Am I right that the 31st of August 2018 was the first letter from your clients to Jamaica?
that's correct, Your Honor.
Okay. So you're talking about a year later, the reliance on that September letter.
Over a year.
More than a year later.
That's correct.
Okay. Thank you.
There was another development, as Your Honors will recall, and that was in June when that was in November of 2019 when Jamaica Customs sought the advice of the WCO, the Royal Customs Organization. And I'll just remind the court that not only did they not copy or even mention the claimant, but they made 3 statements in their application that were incorrect. And Your Honors may recall that document is that bundle B4A, page 80. They stated that there was no dispute with another administration. There was no dispute with an exporter. They did not know whether there are any contrary views. Ms. Davis accepted that the third was incorrect, but I think she maintained to the end that the first 2 were correct. And I'd ask Your Honors to note that she denied having previously said in her evidence that there was a dispute. Your Honors, make a note of timestamp 5/12/49 to 5/13/20. She specifically had said that there was a dispute, and indeed that the dispute resolution process had been initiated.
I want to ask you something about that was on my mind then. You asked about whether the questions and the responses, whether the responses were correct or incorrect. That's what you asked. What I want to ask is something slightly different. You don't have to do it now. When you read that third section 3, right, where the 3 questions arose on the form.
Yes, ma'am. Okay.
What was the, as a question of interpretation, what was the intent of that section? In other words, this is WCO saying, fill out this form. this is the form that we want you to populate. And we give you 3 questions. One deals with authority, one deals with disputed parties, and I
Dispute between administrations and disputed a party, a
part.
person.
And then the third one was
Contrary view.
contrary. So what I would like on the record at some point is, what do you think was the intent or purpose of that section? What information they were trying to gather, and why was that important in their decision-making process?
Yes.
Because I think that may help me anyway understand better. Forget about the evidential nuances, which you pointed out, about whether she said this or not this. What was the purpose of this? Because if you're making an application, then I think that would help.
I'll address that right now, Your Honor.
Sure.
The purpose was, I would submit plainly, to ascertain whether there were contrary views, to ascertain whether the applicant and the position being advanced by the applicant was the only side. And if one considers the 3 questions, not only is there a general question as to, is there a contrary view, but there are 2 specific questions. Is there another administration with whom there's a dispute? Is there an exporter or importer, i.e. a private person with whom there's a dispute? So that the questions put together all sought to ascertain, is there a contrary position?
Is that, Mr. Hilton, so that WCO will consult with
That is-
those persons who may be named?
That's what I would imagine that they would do.
Or at least give them an opportunity to be heard in relation to a determination being sought by one party, which may be against their interests.
Right, so, Your Honor. And indeed, had there not been that form and those questions, I would have submitted that Jamaica Customs would have a duty to point it out anyway.
And that would fall under the umbrella or in the bucket of your consultative process.
Exactly.
And good faith? I don't know.
I may not have gone as far as saying good faith had the form not been there. But I'm compelled to do so with the form. And Your Honor, I should say, I am not suggesting that Ms. Davis was deliberately misleading the court. I should just say that. She is a civil servant with a distinguished career. A civil servant with a distinguished career. But she did make some incorrect statements. For completeness, Your Honor.
It just strikes me, Mr. Hilton, that if states are in a common market, then any issue regarding a tariff heading in a particular state is of consequence and of great interest to all other states in the market, because it
sets a precedent. It impacts
and it has potential consequences. So that no one state can regard a question concerning what is the applicable tariff rate for a particular good as a purely domestic issue. It is not.
Yeah. I was saying, Your Honor, that for completeness, there's one further aspect of Ms. Davis' evidence that I would mention. She said, although there was an error in the form, she made full disclosure in the letter. She says it's at timestamp 5/23/12. Well, it's actually in the chronology. And I just mentioned that that also was inaccurate. And if one goes to the letter, there is no reference to the claimant, there's no reference to what Hamlet quoted, there's no reference to the issue having been raised by nominee. It's almost as if it was an academic question. There's a significant series of events, Your Honors, that followed the advice from the WCO. And if I may now take you to the chronology. If you go, Your Honors, go to page 3086. The advice is given November 22nd, 2019. And in the 2 months that followed, there were a number of developments. So December 13, claimant's attorneys write a very long, detailed letter requesting a copy of the advice, requesting certain things. Customs then meets with what the witness calls the private and public sectors, but of course it excludes DCPS. Read that advice. Blue Power receives advice that the appropriate subheading is for industrial soap. And I just say for completeness that Ms. Davis denied that she gave the advice, that the government gave the advice. Then the ministry directs the trade board, using Ms. Brissett's word, to continue issuing certificates of origin, despite the guidance. Continuing on page 3087, she stopped signing the certificates and the CEO starts doing so. And I just pause, Your Honor, to commend Ms. Brissett for her frankness with the court.
Comment on?
Ms. Brissett for her frankness with the court. Okay. And indeed to commend counsel for bringing this to attention, because I confess I had noticed. But continuing to 2020 on the chronology. Blue Power then submits multiple CIFs classifying the imports as industrial soap. What we have quoted there is just 4 examples. There are others. And I just tell Your Honors that this is throughout 2020 and into 2021.
And as far as you're concerned, it doesn't really matter which representative of the government of Jamaica, for example, signs off.
Not exactly, Your Honor.
Yeah, because the state is
the obligation is the state.
Absolutely. Okay.
It also doesn't matter who directed whom.
Yes, exactly.
Then January 6th, the ministry submits safeguard applications on January 7th for 3 different persons. And then January 14th is this letter from Customs to the ministry saying that DCPS is questioning our sovereign right and not going to answer them. All of these things happen within a less than 2-month period. And these are the responses of the state to the guidance that they sought, which was apparently contrary to what they had hoped for. If we continue with the chronology, Your Honor, going to 30, well, at the bottom of 3087, the Secretariat responds very quickly to the request for safeguard certificates, denying it. And there's a series of correspondence from the claimant's attorneys, none of which are responded to, save for letters saying, we will send a fulsome response later. That sort of letter. And then in September 2020, a Norman 3088 of September 22, the Ministry of Industry writes a letter to CARICOM. So this is now where the direct communication with CARICOM starts. They accept that the imports don't qualify for community treatment, but they make this claim about Jamaican manufacturers alleging quality issues. And they say cause inconsistent odor, cause damage to machinery. Significant. And we submit, Your Honors, that on the evidence, both Martin Phillips' cross-examination and the documentary evidence, there's no evidence to support this statement having been true. Again, I point out that none of this is communicated to DCPS. The allegations were not communicated to them. The fact of this communication to CARICOM was not communicated to them. They discovered after the fact. And we note in this box for completeness the absence of complaints from others. To jump ahead a bit, and jump ahead of the chronology, but we are on this question of quality. Your Honors will recall that in 2021, there is the email about the rancid smell. This is the email from Ireland, which is June 23. And I mention it because there are only 2 complaints in evidence. 2. One by Bomber Manufacturing about the moisture in 2018, and this one. And in relation to this one, the smell one, Your Honors will have heard the evidence as to the other motive, the other complaint that the producer had, which is that, which he expressed quite openly, which is that because of DCPS's complaints, they lost their duty-free export status.
Mr. Hilton, just put together for me, you had brought attention on the smell issue to a report that consolidated 3 manufacturers, I don't know if it was tests or assessments, and you, in cross-examination, you were making a point, I think, that, and so this is where I'm hazy, and this is what I think, correctly, that contemporaneous with or in relation to that batch which generated the email about smell, other independent Jamaican manufacturers submitted reports, but there were no complaints about smell. Do you remember that?
Yes, Your Honor.
So can you just...
And if your honors go to page...
Sorry?
If your honors go to page 3090 of the chronology, 3090 of the chronology, the penultimate entry on that page, April 21, Bureau of Standards reports that DCPS's soap noodles have natural palm oil odor. They are not rancid. And
no, what I'm asking is, I thought, maybe I should hear you first and then.
Yes, if I may.
Sorry.
So there's this document. This relates to the same shipment.
Same shipment, right?
Mr. Phillips confirmed. And what Mr. Phillips confirmed is that the shipment was to Kirk. And Ireland got some from Kirk. Kirk had the shipment tested. Kirk had no complaints. So when Your Honor refers to the reports by the different persons, Kirk's assessment was the smell was fine. The Bureau of Standards assessment was the smell was fine. And Blue Power, a separate manufacturer, when I asked the witness, he confirmed they also had no complaints. So that it is not just that there was only the one complaint, it is that other persons either checked or had it tested or had an opportunity to say and confirm there was no problem.
Mr. Hilton,
Your Honor.
I don't want to rush you, but I think that my brother Anderson had raised the question as to what is the legal effect of good faith. What would be the legal effect? And you promised that you reached there. I suspect that you will reach there.
I thought I may have answered it.
What you did was to identify that there were 2 aspects to it. The factual aspect
and the legal.
Yes. I noticed that you've spent a lot of time on the factual aspect of it, but I'm still, perhaps I'm being impatient.
Yes, and I'm also conscious of the time. So, Your Honor, I will answer the legal aspect very briefly. Jamaica had a treaty obligation to impose a CET in certain circumstances, and there were specific exceptions. That's not an obligation to impose it in good faith or to not impose it if you think that if you honestly think it doesn't apply. Not an application that has exceptions based on this was difficult and complicated, and so you thought it was this. It's an obligation to do it. And there is a avenue if there is doubt, which is to approach the acknowledged decision maker, the regional body. And that is a short answer to the legal question. There was a breach, quite apart from getting into the detail of alleged quality issues. I'll just indicate, Your Honors, and I'm about to move on, that the quality issue.
Before you move on, just to follow on what my brother was asking. So the Vienna Convention on the Law of Treaties, would that be useful at all in this general discussion? As with the ILA, the IC's draft on state liability, I'm just wondering, given where we are in an international court, whether in setting out the law, those kinds of purposes might be helpful.
Your Honor, could give me now. Your Honor, if I may respond to that question later.
Oh, sure, of course, yes. Thank you.
Allow me to give it some thought. Your Honor, I'll end this point by saying that throughout the period, and indeed to today, Jamaica is still not imposing the CT, that the basis on which they have done so has changed. None of the bases were valid. And there were 4 different bases. First, because of the misclassification as 3823. Then, when the WCO advised that that was wrong, they allowed classification as industrial soap. Then they said they were awaiting the outcome of the request for safeguard certificates. Then when the requests were refused, they raised questions of quality and eventually granted PIR relief. And in relation to the PIR relief, as I understand the evidence from Mr. Thompson, they have granted this relief to all soap producers. Your Honor, I turn to the...
Sorry, I don't know if you call it an excuse or the explanation for not imposing the CET. The last one was the PIR relief, the domestic regime. That was available from the very beginning.
I don't recall when they developed the regime. I mean, it was available in the sense that it was a totally internal regime.
I know.
But that's the point at which they are developed.
Because you see, you set out your thing in a sequential manner.
Oh, no.
And so I wondered whether the resort to the domestic regime was one that was available at the very beginning. But it is that they chose not to rely on that until all of the other explanations had been exhausted.
Well, I think that's exactly what happened. Indeed, when you come to the to that regime, the point in time in which they did it was this is now, the matter has now gone to court. And we have now sued, and this is when they turn to this.
That was the tenor of your question. Yeah. I understand.
And the sequence, and I'll just mention one of the things that we point out, I think it's in our chronology, that in fact, the way in which the PIR relief was granted to Blue Power, for example, and to the others, was different, did not comply with the process that their own witness says was normal. So that they said the process was, you apply for relief to the ministry. The ministry recommends that you get relief. Customs then does its investigations and research and checks and decides whether to grant it. In relation to Blue Power, suit being filed and the suit was limited to Blue Power, it seems Customs initiated the process, seek to the relief. And it's a small point, but the Blue Power's defense was, I'm industrial soap. I was told that industrial soap is appropriate. I don't need to pay duty. And then they get the relief. And it then went to that. So I did this sequentially, Your Honor, because in fact they came up on each one sequentially when the previous one came.
But besides that, even if there was a breach of the domestic regime, even if there were, that would not allow us to do anything about it. unless the regime itself breached the RTC.
And again, I guess I'm wondering back into the good faith issue. The fact that they breached their own regime is not a matter for Your Honors.
But you say there was not good faith in that?
Your Honors, the question that the President asked me as to the sequence, the evidence would suggest that they came upon each explanation or basis as each one failed. And that one, claim is brought, responses are due and are being filed. And in the middle of that, a PIR
In relation to
release.
which, in response to the President's inquiry, I think the regime was introduced in 2014.
It was sometime before, yes. Didn't know exactly when.
Yes, but it wouldn't be necessary to invoke that during the time that, before the misclassification had been established, so to speak, because then you have a change of tariff heading, and therefore there is substantial transformation, so you don't need to go there. But now, suddenly, they were confronted with the fact that there was no change in tariff heading, and then to get out of this, you have to find a reason for an exemption. And they found that, rightly or wrongly, in the application of the PIR. Is that?
That's exactly what.
That is that.
You see, Mr. I was trying to show you the time frame, because until your plan became a player in the field, then there was no issue, it would appear.
Exactly. And indeed, the question of who would be adversely affected, it would be a breach, but nobody's being adversely affected or nobody's complaining. Your Honor, this question of the applicability now of the PIR and whether they were entitled to do it. There's a list of condition duties exception, and in our, if I'll just indicate where to find it in our written submissions. At page 1499, from paragraph 38, we set out various submissions indicating why we say that the list of conditional duties exemptions does not apply in the circumstances. And one of the primary reasons why Jamaica did not qualify is the simple fact that they do not manufacture soap, the Jamaican producers. Rule 4A of the list of conditional duty exemptions provides that goods that do not meet the qualifying conditions will not qualify for exemption from duty. And this is a submission made by CARICOM, which we adopt and support.
So that's Rule 4A?
Rule 4A, yeah.
Okay, which then I think refers us, is it to this schedule of Article 84?
Schedule of 84, yes.
Okay, and the schedule has a list of goods, and each product has a product specific rule of origin. Yeah?
It doesn't.
But soap doesn't appear on that list.
Doesn't appear on the.
Okay, so it doesn't appear in Part A of the schedule. There is a Part B, right?
That's right.
And Part B speaks about rules regarding community origin. So where here are you saying that the product from Jamaica product produced by the private sector in Jamaica did not meet the requirements to be treated as a good of community origin? You're not referring to the list because it's not on the list. So I presume you're referring to something in Part B of the route?
So, in those circumstances, they would need to either be wholly produced
Yeah,
in the region, or
which are not, clearly.
which nobody claims,
Nobody,
by the
yeah,
way,
right.
or produced by a process that results in substantial transformation. And,
Which is really a change in tariff heading. Okay.
and there was none.
How do you reconcile that with Rule 1.5, paragraph 5, again in Part B of Schedule 1, so Article 84? Because it talks about something, whether there is a change of tariff heading or not. So I'm just wondering how that relates to the substantial transformation criterion that you spoke about.
Your Honor, we struggle with that. but
I'm glad that the others were struggling.
but you know, we are comforted by the fact that whether there was a change of tariff heading or not, whether a change of tariff heading was decisive or not,
Yes.
the facts were that there was not substantial transformation.
Yeah. So
that,
in your submissions, you're saying that even if there was substantial transformation,
but even if
yes,
a change in tariff heading,
precisely,
the absence of a change in tariff heading
yes,
was not itself decisive.
Yes, because this rule will kick in.
Exactly.
Rule 1.5. And you're saying that what occurred, per se, the side disputes this, but what occurred was basically a simple mixing of materials imported from outside.
Yes, sir. And indeed, it's when both one looks at the documentary evidence and the oral evidence of the witnesses, and this is particularly Norms Brissett, it is heating, molding, shaping, cutting, coloring, fragrance.
The question is, who decides whether that process you just described, I think accurately, amounts to simple mixing of materials? Is that something that this court decides, or is it something that a technical body decides?
It ought to be a technical issue.
Yeah.
And you know, this takes us back to the question of, should these matters be determined, A, on some subjective basis, or B, or just on a basis of the tariff heading change, which is a very objective basis that is determined by technical people, which is what I would submit it ought to be. But if there's a need for determination on a case-by-case basis, it ought to be by a regional body that has an objective, not a subjective, but consistent position, so that you don't have different positions in different territories. And there's a further problem with the PIR, certainly the way it is implemented.
So you are saying then that the whole PIR regime falls, because it cannot be inserted into the regime under the CET that we just looked at.
I would say it is fundamentally flawed, both in terms of how it was implemented, but also in terms of the fact that it effectively changes the definition. It changes the way in which the determination of an exemption can be determined.
So if we started at that point, then everything we have said so far until we got here becomes moot in a sense. Because if the PIR falls, and all of these things and most of what we have talked about since you stood up there become irrelevant. Am I right?
You're correct, Your Honor. Okay. And were I the judge, I wouldn't have said much of what I have. But since I don't know how Your Honors will rule, I have had to cover other areas.
Got you. Okay.
I got the impression that Rule 1, Paragraph 5 is not relevant here. It is relevant when you have a change of tariff heading, because then in principle you would say there is a substantial transformation, but Rule 1.5 says there is that substantial transformation unless it is done in a minimum kind of process. But in this case, there is no change in tariff heading. And so it would seem to me that Rule 1.5 is no application here. Is that your understanding too?
That is our case, Your Honor, that,
yes,
that they don't get past the no change in tariff heading position.
Right.
But I was answering.
You said even if they did, then there was a minimum. But we don't, if that is not so, and I think it's quite clear that there is no change in tariff heading, unless I'm mistaken, then we don't even get to Rule 1, Paragraph 5, correct?
That is correct.
Good.
And there's no dispute that there was no change in tariff heading.
Mr.
Yeah.
Hilton, sorry, before you move on, you know, we've been trying to discuss a little bit about this subjective, objective sort of dilemma. And the whole PIR being a little more subjective, and you've explained why definitionally it may be fundamentally flawed. But earlier you had said something, I just want to try and bring it back to that and get your views. The whole idea of changing in tariff heading, right? So that is only done through CARICOM organ, right?
Okay.
The process, there's a process attached to that.
Yes, well, there's a process both to seek it,
Yes.
and presumably CARICOM has a process to determine it. So that in answer to the question that
In the context of the CSME regime, it would, in a balance, stand to reason that preference should be, or deference should be given. Hence the question that 1.5 does not apply because there's no change in tariff heading. The fact of the existence of the tariff heading is suggestive of the character of the product, the essential character, the fundamental character of the product. That's a presumptive evaluation that courts are bound by. In other words, if CARICOM does this through a process of application, change, and evaluation, application, evaluation, and or change, then that should have the weight of a presumption in law. I'm asking.
No, it certainly should, Your Honor. And indeed, the point that I think Justice Anderson, or the question he asked in relation to, is it something that the court should be deciding? You ought to start with, we all have member states have agreed to a process by which the community organ determines tariff heading. And you have is there a change in the heading? Is it the same heading for input and output? And if so, that is decisive of the issue under 4A and so on. That ought to be the position. Otherwise, you have a situation where individual member states have internal regimes and then come to court, and the court then has to decide is the molding and the plodding machine, etc. Which ought not to be the case.
Just to take care of one small point, going back to rule, is it 1.5 of Schedule 1? What of the argument that that rule represents a special rule? A special rule, and therefore derogates from the more general provision in Article 84.
One of the difficulties with that argument, if I may say so.
It's a question.
I know.
Yes, okay. Good.
One of the difficulties would be that it would so derogate from the whole purpose and intent of the structure that it creates a loophole that we would submit can't have been the intention.
Yes, but the way it is phrased, in a sense, seems to be on your side, because it is saying that it remains a good, or is not a good, of community origin if the process it has gone through, which results in a change of tariff heading, is A, B, C, D, including simple mixing of materials.
Yes. So you should get to the same results in either case.
Not at all. Thanks.
Your Honor, in our written submissions on page 1501, we address some of the issues that I just mentioned in relation to the Jamaica's contention that the soap noodles are materials for use in the approved industry. And we respond to to these issues very largely in the way that I have responded in questions, in answer to questions from Your Honors. Your Honor, we move on to the question of soap being available in adequate quantities within the region. One of the issues that Jamaica raises, and again, just for completeness, between paragraphs 51 and 65, we comment at some detail on this issue of adequate availability. But we make two other observations arising from the evidence. The first, Your Honors, is Mr. Sarendo's evidence about the claimant's capacity to meet the volume requirements of the market. They now produce 1,000 tons per year with a capacity of between 10 and 12,000. And it is more than able to satisfy the needs of the Jamaican market. And this is relevant not only to the breach question, but to the additional ground that we've noted that Jamaica raises in its additional issue that it raises in its submissions. And Your Honors will recall that on this question of consultation and of the process that was followed in determining whether to grant the PIR, those steps did not include checking to see what was the position in the region, what was the availability, what suppliers there may have been, and indeed no communication with the claimant. And Your Honors will recall from the timeline that they knew from 2018 August about the claimant's willingness, eagerness to supply the Jamaican market. But when they're applying the PIR in 2019, that's a fact that they knew, a fact that they did not take into account.
When you talk about capacity, you're talking about the capacity of the plant to generate 10 and 12,000 tons?
Yes, sir.
Per what?
Per year.
Per year. Okay.
And are only doing one.
Does that answer fully the question of capacity, though? Because that is just the plant that is there, but you have to get the supplies.
Yes.
From some of the raw materials, from maybe they get it in the Middle East or wherever. And I assume that there are other factors that go into that equation. So what I'm asking, in other words, is simply having the plant there with an overall capacity of 10 to 12,000 tons per year, answering the question of capacity.
Well, Your Honor, the witness's evidence, as I understand it, was, if I may just ask you to note, timestamp 1:37:00 to 1:40:00. The evidence of the witness is that the claimant can produce and supply this quantity. And that evidence, I think, would not be limited to, I have a machine or a plant that can do it, but I can get the raw materials.
So
and indeed, when it's complete.
Didn't he say that they are now producing 1,000 tons?
Yes, sir.
And that they could go to 10 to 12,000, and that for Jamaica they would need 180 tons. Is that correct?
You said 180 per month.
Per month.
Which then would be 1,200, 1,500.
Yeah, would still be
well within.
Very much within that capacity.
Yes, but I was just answering Justice Anderson's point. I don't think his evidence was limited to the plant has the capacity.
Right.
Because the other witness, Mr. Nassif, also spoke to the process of importing, the time lag, the availability and so on of the raw materials.
Yeah, well, I'm just wondering if, to be fair, whether we would need to look at the balance sheet, for example, because I presume you'd have to order these things from the Middle East.
Yes.
The other factors that go into the question of whether there is capacity to produce, yes.
And indeed, before one makes a decision that there's no capacity in the region, those are things that the decision maker would look into.
Mm-hmm.
And I accept that the decision maker would not just simply take Mr. Sherman's statement.
The physical plant. Yeah.
But Mr. Hilton, just checking evidentially, because the court of original jurisdiction, the evidence we receive has to, assuming apply the usual rules to assessment. Was there any attempt to challenge that evidence capacity?
No, Your Honor.
Were the witnesses challenged any? So that is it then correct that that evidence is now uncontested for the purposes of this hearing?
It is, Your Honor. And indeed, I think we say that in our chronology.
Yeah.
Am I wrong? But I got the impression listening to, I think it's Ms. Davis, the second to last witness yesterday, that Jamaica was more concerned about the smell. I do recall she emphasized quite a few times the odor. So they didn't seem that concerned with the capacity of the plant, but with quality. And I think her witness statement had paragraph 30. They put both together.
Well, all of the witnesses for Jamaica, I think, they tend to say quantity and quality. But if one looks at the detail of what they then say, there's nothing really about quantity, save for the period of, we made a request in December, we said we were closed for the month, December into January, and then we would need 4 months. So those are the two quantity issues that they raise, if you would. And you recall, Your Honor, that in relation to both, there were explanations that this is not that we have an ongoing problem. This is that we don't have stock from wherever in the Far East sitting in the warehouse waiting. When we know that there's a series of orders and a clientele, we can order in advance. So, which was the answer to that point. But apart from that, Your Honor is of course right, that their focus is on quality. And because if we go back to, they only in fact have one complaint about quality, and this is the smell email and the moisture one from 2018. And that's why they kept on going back to them.
Just to say that in an international court like ours, the sort of strict rules of evidence applying in domestic law they are relaxed a little bit. I mean, I take the point.
I've noticed.
You'd appreciate that. Okay.
Your Honors, I'm conscious of the time. I know that Mr. Gibbs is getting a little anxious. If I may turn over to him to address Your Honors on the question of the certificates of origin and an aspect of the CET.
An aspect of what?
An aspect of the CET.
Okay.
May I please, Your Honor?
I hope you're coming back to your paragraph 60.
I am, Your Honor. Justice just reminded me I need to come back.
I'm sure you're not going to be as short as you were yesterday.
Hope to be. I don't want to make promises I can't keep, but I hope to be. So, Your Honors, I will be wrapping up some CET issues, hopefully very briefly. I'll start by addressing issue C and issue D in the claimant statements of facts and issues. That's at page 2,995, the yellow bundle. Mr. Hilton described them already. I won't go through them, but issue C relates to consultation and whether it was necessary in the circumstances. And issue D relates to Cortez's decision at the first meeting and the effect that decision may have had on any alleged right of Jamaica to exempt CET unilaterally. Now, these are alternative arguments, assuming you don't agree with Mr. Hilton that the CET, the conditional duties exemption regime does not apply to soap imports. Then I'll go on to address the certificate of origin issues. So let's start with the consultation issue. And our submission is this. Even if Jamaica's exemption regime could apply to these circumstances, Jamaica had a duty to conduct proper consultation.
And where is that based?
Pardon?
Where is that sourced? Where's the basis?
Article 26 of RTC.
But Article 26 seems to impose an obligation on the community
Your Honor, there is some case law from this court, the rock hard cases, where they suggest that the obligation is not just the community, but member states as well. There is also a case from 2009, which is I think TCL and Guyana, where there was some comments on that as well. So it's not the consultation duty, it's not just quoted or CARICOM organs. Also member states have that obligation as well. And I'm going to make a submission that kind of explains how I get there.
Okay.
So your honors will notice in the statement of facts and issues, we actually frame the issue as whether there was a duty to consult quoted. I think it's a little wider than that. And I want to phrase the issue to be, did Jamaica have a duty to adopt a proper system of consultation? And we're going to say that the answer is yes. So Jamaica should have properly consulted quoted, we say, and Jamaica should have properly consulted DCP, we say, before granting any full exemption of CET. And I mentioned to the panel when you asked the question that there is case law that suggests that member states as well have this duty. I'm going to read a quote from the Rock Hard Cement and Trinidad and Tobago. I don't necessarily think it's the best quote for this. I think actually TCL and Guyana case may have a better quote, but a quote is a quote. So at paragraph 44 of that case, this court said, Article 26 of the RTC calls for the establishment and maintenance of an efficient system of consultations at national level and the regional level. And then it goes on to say, the competent authority of Trinidad and Tobago, having the responsibility to consult with the second and third claimants, seriously attempted to do just that. So that was a case where there were arguments about whether Trinidad and Tobago should have consulted with some of the parties to the claim. And that's what the court said.
Were those parties regional entities or were they domestic?
Those were, I think, they're cement companies.
Pardon?
Cement companies.
Right, so there were domestic entities within the jurisdiction. Yeah.
So we do accept though, that the value of consultation processes or the importance of the consultation process really depends from case to case, or the extent. It's a case to case, should be judged on a case to case basis. But we see in this case, in these circumstances, in this situation, it was extremely important for Jamaica to consult or have a proper consultation process with DCP.
Yes.
Just
I
like
hear you.
quoted what, sorry.
I understand what you say, Mr. Gibbs, and I'm sure my colleagues as well. My difficulty is, and I want you to help me, is just the way 26 is phrased, because it does seem to be phrased as imposing an obligation on the community, community council, shall establish a system. And you are asking us to find Jamaica liable as a member state because the member state did not consult with the community. And you're using as your basis for that 26. But 26 seems to be placing the obligation to establish this consultative process on the community, and in particular the community council. So that and I know what we said, you know, as part of the bench said it, but I'm just wondering whether you can transpose that dictum you read there to the current situation. We were talking about the member state vis-a-vis not people within its jurisdiction, but vis-a-vis the community on whom the obligation was split.
I think you cited from Lockhart, saying from its inception, therefore, that is what the court said, proceedings with respect to suspensions of the CET have been read by this court in light of Article 26. This requires the member states of the community and the community itself to adopt a proper system of consultation to ascertain the impact of a proposed deviation from the CET, etc.
Yes, sir.
I think that is what you are getting at.
Yes, yes, Your Honor.
It's not just the Article 26, but more or less what comes out of that.
And I'm going to take it a step further. You said it better than I could, but I'm going to try to match. Your Lordship.
You're most welcome
You have to try.
So here's what we say. We say the power to lower, the power to raise, the power to suspend, the power to alter CET. That's quoted's power. And this alleged exemption regime is really a delegation of quoted's power to the member states. So if the exemption regime does apply to the circumstances, the competent authority will be exercising the power that quoted delegated to it. Therefore, it has the member state has the same obligations to exercise that power fairly, to exercise it transparently, to exercise it with appropriate consultations with the manufacturer who they know would be affected by the decision. And so I think, I don't know if I've matched, but I hoped that I've come close to matching his lordship's formulation of the obligation of consultation under section Article 26 or on the member state. I just want to pause if Your Honor has any further questions on that.
On that point, no, I don't. Thank you.
So we say that Jamaica has breached the duty in this case. Jamaica claims that after 2019, soap producers benefited from the PIR regime, and that they didn't breach the duty because of this. But the only hard evidence that we have seen in the bundles of any approval was the approval granted to Blue Power in September 2021. They didn't consult quoted before granting that approval. Jamaica did not consult DCP before granting that approval. And in the circumstances, we say that consultation with both quoted and DCP was appropriate. And here's why we say that. First, Jamaica knew that DCP was a manufacturer of soap. And I say manufacturer because I think my manufacturer means something different from other persons. Manufacturer means they saponified soap. They took a raw material, the tariff code changed after they put it through a particular process. That process being saponification. So they knew that there was a manufacturer of soap in the region. Jamaica knew that DCP was claiming that it was negatively affected by the failure to impose CT. Jamaica Customs received several letters from DCPS's representatives on the issue. Jamaica knew that their purported decision to waive CT was contrary to a decision quoted made 9 months earlier. And Jamaica was purported to waive CET based on quality issues allegedly experienced by Kirk distributors and island products. So those are the circumstances. And we say in those circumstances, a proper consultation would have required reverting to DCP, allowing it to respond to any allegations of poor quality before granting relief, and notifying quoted of its intentions to grant an exemption, because that would have allowed member states who would have already pronounced on the issue on the 51st meeting to say whether they objected or they didn't object or had any view. If you listen to the evidence of Ms. Davis, she confirmed that the type of consultation that happens at the quoted level is similar to what we're suggesting should have happened. She referred to a Belize matter with the CT that applied on sugar and highlighted how there were consultations with quoted and other member states to come to that decision in that matter. That's the type of thing we're thinking of was appropriate in this case. So, we say that in these circumstances, quoted should be consulted, DCP should have been consulted. There's a quote here that I was going to read to you, but I think His Honor,
Mr. Gibbs,
Justice
you said
Wick
in
may
these
have-
circumstances, what is the consequence? How does this sound in law? How does this sound in law? How does this sound? What are the okay? So you
What's the
say they
consequences?
should, yeah.
No,
You
this is
started-
an alternative argument, right? We didn't raise this.
No, I understand that,
Yes.
but
So if one were to decide that the conditional duties exemption regime is valid, the PRR regime is valid, we would just say we still would like the order that we sought in our originality application. I think it's order number 2. I don't have my. which in effect would vitiate the decision and require them to apply the CET, and then
No, but Mr. Gibbs, I don't want to. I'm just trying to. You started saying what the consequences were if your position on consultation is accepted, and as you say that was not done, then what?
then I think we should still get relief that we saw, which is that an order made that that CT should be applied on soap imports. I just want to use the order.
So are you saying then that the failure to consult, as you have described, vitiates the decision
That's my
completely?
That's my submission.
But you want more than that. Sorry, I mean, if we pass the point of the obligation to consult, and we say there is an obligation, it's
So just to give you the exact wording that we sought in our
Yeah.
pertinent application, an order requiring the defendant's customs officer to impose the 40% common external tariff applicable to soap unless the Council for Trade and Economic Development grants a suspension pursuant to Article 832 or Paragraph 19 of Schedule 3 of the treaty. Now, I suppose if it is that the conditional duties regime that they have implemented is valid, they will have the option of just consulting and doing it properly and then granting the waiver they claim they can grant. But obviously our main submission
No,
is,
I know that. I'm on just on the consultation, so that the consultation deficit would be cured, just on the integrity of your own argument,
yes.
would be cured by ordering compliance with a due process of consultation. That's how this would play out theoretically.
Yes, sir.
Yeah. Okay.
well, I'm still a little puzzled. When you say to consult, what does that mean? I mean,
At least in this case,
yeah.
where you're claiming quality to be the issue and be the basis of your waiver, at least come back to DCP and allow it to show that the quality is not an issue. That may very well give rise to a different result, assuming that quality really is the issue and not a pretext.
Yeah. Maybe I could raise with you the point I raised yesterday about whether there's some regional standard. Do you have a view on that?
Your Honor, I know that in the Hummingbird case, I believe, there is a regional body that does quality assessments. COSCU.
Yeah.
And there was a suggestion to go there. That's what we think would be appropriate here if you have a quality concern about soap. It is an objective body, that's a regional body, affiliated with CARICOM, that can make a decision on the issue.
And if you were to consult COSCU, you'd have to take the advice, I imagine.
Yes.
Right. So consult. It's just like when we use it in domestic law, which we're not. It's like a different kind of meaning. All right. Thanks.
So I just want to move on to a short point about quoted explicit direction. It's a simple point. You will see page 4A, bundle 4A, page 157. I don't know if it's readily available, but I can tell you what it says. You will see that the quoted held its 51st meeting, and they made a decision. That's the communication that CARICOM would have sent out to all the various customs agencies. And one of the decisions that is outlined in that document is that the quoted reminded member states that importers of soap chips / pellets / noodles of tariff heading 340120.90 from extra-regional sources be liable to pay the 40% duty upon the importation unless a suspension of the common external tariff has been granted. And considering that Dominica raised this specific complaint against the state of Jamaica, I don't think there can be any doubt who this direction is aimed at. This started way back when Dominica complained at the 48th meeting about misclassification. And then the complaints continued until they culminated with this decision. So the decision clearly said that soap noodles should attract CET unless there's a suspension. Suspensions are governed by Article 83 and arguably says Schedule 3, Paragraph 19, which is specific to soap, or for oils and fats. And Jamaica didn't apply for a suspension before purporting to lower the CET because they thought they didn't need to. But the actual direction from quoted was that you should apply the CET unless there's a suspension.
But, Mr. Gibbs, it strikes me that in the face of that directive or reminder, a domestic regime that is inconsistent with this reminder is of no validity.
Yes, Your Honor. That sounds like a reasonable conclusion.
But that's why you call this alternative
Yes.
subsidiary.
Yes,
Reason.
yes, Your
Right?
Honor. Yes, Your Honor.
It cannot be that in one locale of the common market there is a rule that is specific to that locale, but in the rest of the common market there is the rule that complies with this reminder. But anyway, yes.
Here's another point, Your Honor. Quoted, this is a binding decision because it's an Article 29 qualified decision. Binding. So, whatever is in the Common External Tariff explanatory document about member states being able to unilaterally grant exemptions, I think we will submit is superseded by this quoted vote at the end of 2020, the beginning of 2021, which is binding on all member states. In other words, if court had delegated this power, if it gave this power, by this decision is taken away the power. Saying you need to apply for a suspension if you want to lower the CT on this specific problem.
And that was established by evidence that this is a decision pursuant to Article 29.
Yes. If you, I may show you at the bottom of that communication. Like even in the document itself, it refers.
Yes, 29. Okay. I need not detain you on this.
I mean,
That's
I
fine.
think it's on page. So, all right.
So
I
sorry.
think the last issue should be the quickest because of how the evidence. Your Honor had a question regarding.
No.
So I'm going on to certificates of origin. I hope it to be the quickest because of how the evidence came out. No one disputes in this case that Jamaica issues certificates of origin to products that didn't qualify for them. And as you heard, Mr. Hilton, products only are entitled to a certificate of origin in two circumstances: where it's wholly produced within the community or where there's substantial transformation. And so substantial transformation has two prongs. It occurs in two ways: where the final goods produced have a different tariff heading than the materials used to produce them, or where goods appear in the list of Schedule 1A and meet the conditions outlined in that list. Either claimant or defendant, amicus curiae, in this case, is arguing that Jamaica soap producers satisfy any of those requirements. And I know in her oral testimony, Ms. Brissett readily admitted that the Trade Board issued the certificate because the ministry told them to do it. Let me use her words. Directed them to do it. And she herself said that she thought that they should follow Quoted's decision, but her superiors decided to go according to the ministry's directions. And we say that this is an admission, not just a breach, but a deliberate breach. We note the entries in the chronology. I just can tell you there are some entries in the chronology that illustrate some of what I'm talking about here. December 28th, 2020. I won't carry you to them because I don't think I have that time. So just to wrap this up, Jamaica's submission goes on at great length about whether it was appropriate to apply for a safeguard certificate, sorry. We don't plan to spend much time on that, and I don't plan to spend much time on that because I promised this panel that I would wrap up very quickly. and we adopt the paragraphs 18 and paragraphs 19 of the CARICOM submission on that point. And unless you have any further questions from me, those are my submissions.
Yes, thank you.
Your Honors, I recognize that we are almost at the end of our time. Your Honors, if I could ask you to go to bundle 1, page 3001. So these are the last 2 pages of the statement of facts and issues filed by the defendant. And I wish to take you to issues 6 and 7. Now, issue 6 says whether the claimant had proven its ability to satisfy the quality and quantity requirements during the relevant period. And I submit, Your Honors, that this is a, with respect, misconceived issue. There is no duty on the claimant to prove its ability. The defendant has an obligation to impose the CT. It would have an obligation to establish a basis, that there was an appropriate basis to not do so. And if part of that basis is an alleged inability to supply, the burden is on the defendant to prove it, because it is an exception to their primary liability. So I start there. The claimant has, however, given significant evidence as to its ability. And for the purposes of this ground, I would rely on our written submissions at paragraphs 51 to 65. And it is addressed at some length, so I won't take it there. But I'll rely on that and on the evidence from Mr. Sorrento, which you'll find the references in the chronology. This is evidence in relation to the capacity we discussed earlier as to quantity, time frames, and so on. So that will be my very brief response to what I call the alleged issue 6. Then I need to spend a little more time on issue 7. So issue 7 reads, whether in light of the concern to the quality of the claimant's soap noodles, the claimant has shown that it was deprived of benefits. Now, we submit, Your Honors, that the same grounds and factors that persuaded this court, to grant the claimant leave to file this claim would apply here. The claimant is a person entitled to claim the protection of the treaty and the CT, subject, of course, to the other factors that were cited in support of the application for it to be a claimant. And it is plainly directly affected and prejudiced by the defendant's breach. But the claimant went further and led the uncontradicted evidence. And I now ask Your Honors to go to bundle 2. Bundle 2, Your Honors, at page 1323.
Sorry, page again?
1323. Your Honors, in Mr. Nassif's witness statement, starting at paragraph 36, he gave specific examples of the nature of the prejudice that DCPS has suffered and the way in which it has suffered as a result of the benefit of which it has been deprived by reason of Jamaica's failure to impose the CT. I would also add to that DCP is an entity based in a lesser developed country in the region, and it has almost no footprint in the largest market in the region. This alone shows how Jamaica's actions as the pride claimant of the benefit of the treaty. The defendant's formulation, finally, starts with, in light of the concerns with quality. And I confess that it is not clear how that should affect whether they are affected person of being deprived of the benefit. But in relation to the extent that the defendant is going to submit, that since there are concerns about your quality, that means you have not suffered a deprivation of a benefit. We rely on the submissions we have made, perhaps at too long a length, on the issue of quality. So, Your Honors, those last two issues we would submit are not issues that ought to detain the court longer than not issues which the defendant could rely on in defense of this claim. Your Honors, unless there's anything else I can address.
Article 84 speaks about specifications, not about quality. How do these two concepts come together or not?
Well, interesting, Your Honor, the ground in the raised by the defense is not in relation to Article 84, it's in relation to Article 82. But to answer Your Honor, I think they're separate concepts.
You think what?
Separate concepts.
Separate concepts.
Yeah. Even though one of the witnesses yesterday did suggest that they were one and the same thing. But when they talked about quality, they were talking about technical specifications. So
I didn't recall that.
yes, that's one witness said that for the defendant, of course.
Yes, well, thank you very much, Mr. Hilton. We take a short break, and then when we come back, we hear you, Mr. Simpson.
All right.
Yes, Mr. Simpson.
May it please your honors. The State of Jamaica has filed written submissions, and I intend to rely on them in great measure. But I wish first to indicate two matters for correction. Taking you to page 2368 of record 23.
Page what?
2368.
2368.
Paragraph 22 misrepresents the evidence. It refers to the WCO in its ruling, indicates that tariff headings 2915, 3401, and 3823 merit consideration. That can give the wrong impression. What the ruling indicated is that there was a consideration of the three, but the merits were not. The only one that it deemed to be meritorious in its advice was 3401. The matter, the court is being asked to consider, make a determination effectively, 5 or 6 orders that revolve around determination of whether Articles 82 and 84 were breached. Declarations in relation to those two, consequential orders compelling the state to take certain recourse, and the claim for compensation that flows if those breaches are found. Mindful of the court's time and resources, the state must concede that in all the evidence, Article 84 had been breached by the state once the quoted decision of January 2021 would have been issued.
Once it was issued.
Once it was issued.
Did you put a date for that decision?
In fact, I will restate that. Once the tariff heading would have been reclassified, and that was confirmed, the decision of January 2021, the saving gram reference that my learned friends would have pointed the court to, from that point, it would have been without dispute. The tariff, effect of a tariff heading change would have deprived the state of being able to grant certificate of origin. The evidence of misprisit makes that clear. We will not detain the court on that aspect. But in relation to determining, it doesn't, the court is in, urge the court to consider based on its rules.
May I commend you on that clarification? It helps. Thanks.
I appreciate I'm starting on the right foot.
And you can be assured that Justice Barrow is hearing you well this morning.
I think he's always heard me. The problem has been the witnesses. I will try to maintain my composure as I. It's a sort of submissions that require safeguards, and I don't seem to have enough of them.
You're applying for one.
You mean once I am not hearing you well, it means that there are some things which you don't want me to hear? Okay.
I can't escape them, so I say them as clearly and squarely as I can.
All right.
In determining whether, to resolve the issue of whether these articles have been, the consideration of the breaches, it's not simply that it has been breached, but whether the breach was serious, that the party affected suffered substantial loss, that there is a causal link between the breach and the loss or damage. This submission is supported in law by the decisions of this court in the Hummingbird Rice Mills case, paragraph 55, and also Trinidad Cement Limited and TCL Dine Incorporated,
I think, Mr. Stimson, that we had agreed to prosecute the case in two phases. First was whether there was liability or not. And then if there was, we would go on to the next phase.
I'm giving the overall scheme of what should be considered. Not that I'm expecting this to be determined now, but I did appreciate in the claimant submissions that there were questions regarding damages. So it's merely the submission to flow as this matter progresses. But we are going to be narrowing our discussion on whether there was a breach. But we have to consider the seriousness of that breach to determine the issue of liability and the status of the affected party.
No, sorry. If there was a breach, then there's liability, surely.
There is liability if DCP has not established that it would have suffered as a consequence of that.
Then that goes to damages.
Goes to damages.
Which is the second phase of the trial, which we haven't gotten to yet.
So the court will consider those issues in terms of matters of the claimant's ability to prove an entitlement. We think go to whether that's the fundamental question. If you are to establish that you are entitled to them, you must establish throughout your evidence that for the period you claim, January 2018 to December 2021, that you would have been entitled to these benefits had an affected party when the particular breach occurred. That's the better way.
Okay, as I understand it, you're saying that the State of Jamaica accepts that it was in breach from January 25th, 2021.
In respect of Article 84.
In respect of Article 84. It doesn't so accept before that date.
No, it doesn't.
And you're going to address us as to the reasons why.
That is so. The time is important because the claimant's evidence claim is that from 2018, it would have been a manufacturer of soap and it was deprived of certain benefits under the Caribbean Communities regime to entitle it to fair competition and access to markets. The reality is, however, I appreciate my learned friend's industry, which has become his hallmark in his chronology. But just to add some context to that chronology, we need to look at the full facts, other relevant information that needs to be inserted. Between 1995 and 2015, DCP Successors Limited did not exist. It was a multinational corporation in the Caribbean which produced, as Mr. Sorreno has confirmed his evidence, several brands which were produced for export extra-regionally as well as within the region. In 2014, Jamaica created its PIR regime to incentivize production of certain local productive sectors, including manufacturing, by granting import reliefs consistent with contents. From December 2016, Jamaica Customs would have afforded manufacturers import relief under that PIR by designating them. I urge the court to consider 104B, page 2717. My friend indicated that my friend Mr. Gibbs indicated that there was no reference to a designation for the PIR prior to 2021. But the scheme of arrangements was of long standing. And there's an example in the evidence for the court to consider in 4B. Now, in respect of DCP successors, the evidence before the court is as my learned friends have represented, but there's more. Through Mr. Nassif's evidence, at timestamp 4040 to 4102, he agrees that in 2018, DCP did not produce palm-based soap noodles. He agrees that most manufacturers relied upon palm-based soap noodles. That's at timestamp 4106 to 4121. He agrees that DCP was not in a position to supply the demand for palm-based soap noodles in Jamaica.
Sorry, you agree that what?
That DCP could not meet the demand by Jamaican manufacturers for palm-based noodles when it was initially sought That's his evidence at 4154 to 4211. My Lord, Mr. Justice Anderson.
Sorry, yes, but you saw the question on my face. No, I thought that what he was saying was that, of course, we can tomorrow morning get up and meet the demand. We have to order the raw materials, and it takes a while to get to us, and so on. So, sure, we can't supply tomorrow morning, but if you indicate to us that you're going to take it from us, then we'll order and get the thing in from where it's coming from. Isn't that what you were saying?
It was more than that, sir. It was in fact the fact that they were producing with tallow, and the market did not provide that. So when it was in demand initially, it would have been made. The majority of the market did not require what they produced. They changed their line, but that line wasn't changed until 29.
We change your line to accommodate the request of Jamaica.
That's the suggestion, but it changed this line across the markets. But if we appreciate that, at that time, what we have is we have within the region two different markets. We have two players, one from Dominica, some from Jamaica. Dominica, by Mr. Sereno's evidence, is starting from scratch. It's acquired a plant with no brands, building itself up. It's looking for active markets. It's now seeking, its focus is soap. It comes to Jamaica to try to elicit invitation to buy their raw material. Jamaica doesn't use that raw material. It uses a different one. One tries to buy, Blue Power takes a sample, they don't take it on. They change their design, they say to attract this market. But the evidence is, within the Jamaican market, manufacturers are not satisfied. They don't deem it acceptable. The wrongness or rightness of that is not as material at this juncture. Because what we have to consider is, at this time, there is no captive market in Jamaica, no continuing existing market for prejudice to have arisen. We have a circumstance where they're trying to build and establish themselves. So we shouldn't be equating their plant's capacity with what they can afford to actually engage in. And they're building a reputation. It's an unknown. It's a virtual unknown, which is the reality of what the evidence in quite candid terms has been expressed. An unknown which also underwent significant challenges. 2 hurricanes destroying its plant from the time of acquisition between 2015 and 2017. Hurricane and a tropical storm which caused flooding. That's the evidence.
Mr. Simpson, does it make a difference that tariff heading 3401, does that tariff heading make a difference between, let me back, whether soap, noodles, whatever, is tallow or palm based, does not affect the tariff heading? Is that correct?
It won't affect the tariff heading, Your Honor, but it will affect the market appetite, the desire for it. There can be effective supply must be tied to a demand. And what's undergirded in this entire regime is that there must be the ability for within the region for there to be a free movement with certain protections for markets. If there's no demand for what you produce, the regime does not seek to force manufacturers in other jurisdictions to comply. So if it is that DCP, in establishing itself, saw the need to align its product to the part of the region that had 50% of the market, it's a good idea. But the uptake is not mandated strictly by quota. It must be considered within the holistic scheme of what is envisaged, which is there a desire for the product within the market?
Help me here.
Yes.
You open up from a fresh consideration whether, following from what my brother indicated, the importation of soap noodles from outside the market, that should attract the CET, whether palm or tallow. So that attracts 40%.
Yes.
And you cannot deviate from that unless there is no local supply, and then you get your exemption or whatever.
Or because soap, however, is not a protected good, it's not on the list of ineligibles. And under the regime, there is a framework for each member state to create a structure to manage.
Oh, no, I'm not reaching there
You're
yet.
not there yet.
No. What I'm getting at is this. Jamaica is saying that because the soap that we are importing is palm and not tallow, and what is being supplied is tallow and not palm, we are therefore relieved of the 40%.
No, remember, timing is everything.
Huh?
It's just at this time in 2018,
Right.
there is a classification by Jamaica of soap-based noodles by their more chemical term, fatty acids,
Right.
and they are described on various inputs, and they are applied at tariff 38.
Right,
Under that tariff, the CET would be 0 to 5%.
right,
At the tariff which was decided by quoted, supported by the advice of WCO, been applied, it would have been a different consideration. But to the first issue, I think, and that's, I gave the introduction to give a context to where we were. But for the period prior to 2019 November, when Jamaica got its advice, and once
Mr. Mr. Simpson, you have me at a loss there, because what you seem to be heading up to is to say that there was a misclassification.
I can't, the fact that Jamaica changed the classification is a recognition that it took the advice of the WCO.
Which means that it was classifying it wrongly before.
But that's not a breach of the tariff. Jamaica didn't fail to apply the CET, it just applied the wrong tariff. It wasn't exempting, it was.
So if you misclassify something and you apply the tariff to that misclassified something, you are saying that it is properly applied, notwithstanding that what you are applying it to is a different thing?
What I'm saying, Your Honor, is that you must consider whether Jamaica breached Article 82. Article 82 by its wording is you failed to abide by the termination of quoted. If I'm paraphrasing. There was no determination of quoted on this issue until 2021.
We're
So
clear on
prior to that, and the decision has no retrospective effect.
Right.
So Jamaica's actions before that determination are not a breach, because what must be considered is when there is a determination of a dispute, a concern, wasn't raised before. Jamaica had its justification for its approach by the definition on what the item was. It was confirmed subsequently that that is wrong, so they changed the position. So if we're considering a breach of 82, we must consider, did you breached it once it was determined that that should not be the position?
If you are doing wrong, you don't know you're doing wrong.
Don't know you're doing
Right. Until you are told you are doing wrong, you are not doing wrong?
So the effect of a consequence upon you, when you realize that this is happening, the consequence to fall, based on this case, we're looking at only at a wrong. What's the effect of this wrong on a particular part of the claimant? At the particular time, prior to 2019, DCP was not in a position to be a market that Jamaica would have considered. So even if we are wrong, where is the loss to DCP? DCP is in a different stream. We've seen Canada. Jamaica is importing from the Middle East, from the Far East and Malaysia, palm. It doesn't produce that. We're not dealing with a protected good that inherently requires protection. We're dealing with the classification that says, based on our market, if it is not a protected, if it's not under the list, we consider the tariff headings. When the determination is made that the tariff heading is incorrect, prior to that date, Jamaica acted to changed the approach and reclassified. In reclassifying, Jamaica recognized that soap. If you look at the tariff heading, for example, on 34, there's industrial soap, and there's a classification of other. There's no reference to soap pellets, salt, or fatty acids. No such description. There is no clarity on the point. So in this respect, we can speak to the intention and the conduct. And you're at a place where there's no clear determination. Makers have acted in secret over this period of time. Once the matter is raised, the thing is interrogated, and they realize, well, they quoted the CETs based on the harmonized system. The harmonized system is what they've adopted. Where's the source of that? The World Customs Organization. They go there, they get the clarification, they set out, and my friends have highlighted the document and said that not enough information has been portrayed to show that there's a dispute. But what I ask you to consider form over whether form is more material than substance. In that application, they set out what are the three considerations, the three sections that are considered by the Bureau of Standards, Rule Part 29, that tariff heading. They have applied, which is 38, and what was brought to their attention, which was 34. And the WCO makes the advice that says neither what you did nor what the Bureau of Standards said is the best view. Best approach is 34. And they then, from November 2019, changed their approach.
Would you accept that the correct heading is it 3401?
It must be, yes.
Right. So that prior to, when was it? You were applying the wrong tariff heading.
I'm not trying to evade that.
Oh, okay.
It's really confronting.
But you're saying that you did so in good faith? Is that
that point you're doing it in good faith? And from the standpoint of this claim, a declaration can be made as to when the tariff would have been. I'm urging this court to consider that when you are applying 28 rule, considering Article 82, and if it has been breached, must be considering when a determination of quoted would have been breached.
Well,
sorry.
If the wrong classification is being applied, then there's a breach. There's no difficulty with that because, 82 says that the member states shall establish and maintain a CET in respect of all goods which have been qualified for community treatment in accordance with the plans and schedules set out in the relevant determinations of quoted. So it's an existing duty on member states to basically act in accordance with the classification of quoted. So you're admitting that that wasn't being done, so that is necessarily a breach. The question is, well, that's necessarily a breach. It seems to me. It is necessarily a breach if you are misclassifying the good.
But if I'm applying the HS system, it says I must apply the conditions and abide by determinations. I've applied the wrong condition. So if I had ignored the CT altogether, I would appreciate the view that I've been in breach from the get-go. When I've been in breach is when I've determined that I've applied. It has been considered and determined that no.
So wait, hold on. So are you saying that the quoted, the CET that is applicable only kicks in when quoted says it kicks in? I think what our brother is raising with you is quoted declared what it should be, but what it always was. In other words, it never changed. The admission of a wrong classification is an acceptance that this ought to have been classified as 34, is it 01? Yeah. As under the 34 tariff heading. Mm-hmm. But I think what our brother is raising with you is the fact that that always existed is what Article 82 is speaking to. That regime that it speaks to doesn't kick in when it is declared or confirmed, maybe is a better word. When you went to quoted and got an opinion, did that create the tariff for soap, or did that simply declare to you and to CARICOM states, hence the issuance of, I don't know if it was a reminder, that look, bear in mind that for soap noodles, the tariff is 40%, the CEP is 40%. in accordance with quoted existing tariff regime. Which is it?
So well, I'd say
No. First of all, I think it's important to choose which is it. Is it that with the decision, the 40% tariff was imposed? Or was the 40% tariff always applicable, but only declared or reminded about with the quoted decision?
what view is this, sir? If you'd permit me, Your Honor.
Sorry, what?
If you'd permit
Me.
Sure.
there was no clarity. Had there been
What you mean there was no clarity? No
It-
clarity by
as
who?
to how for Jamaica, and by virtue of how this matter escalated from the 47th meeting of Code to the 51st, to determine the appropriate tariff to be utilized in respect of such.
So let's pause on that. If Jamaica was unclear as to the appropriate tariff, let's take your premise. Quoted has established tariffs. It's all there in the schedule. All right. Jamaica formed a view as to what good it was because it applied a tariff. All right. If Jamaica,
And in so doing, it would have complied with
in so doing, it may have attempted to comply, but may not have complied. That's a distinction that our brother is raising. Because you set about to do something, let's assume with good intent, does not mean that you have done the thing that you set about to do. Quoted has established a regime. Jamaica attempted to comply, but in that attempt, misapplied. That doesn't change the reality as to what it ought to have been. In 2019, all that happens is Jamaica comes and says, what's the right tariff heading? And all that quoted does, I think, is say, this is what it always was, this is what it is now, this is what it must be for the future. To everybody in CARICOM, apply it unless you get a suspension. Is that accurate?
there's one other step. Jamaica take report. Jamaica provides what its guidance from WCO, which is the author of this this HS system that has been adopted by Quoted, and receives an explanation for what hitherto has been unclear.
Unclear to who? It wasn't unclear was it unclear to the WCO? Was it unclear to Quoted? Who was it unclear to?
It was unclear to all the players within the community, to the extent that.
But hold on. Dominica complained. Dominica had they were of a clear view that you were applying the wrong tariff. You went to Quoted, Quoted told you you're applying the wrong tariff. You went to WCO, they told you you're wrong. When you say unclear, I'm willing to accept that Jamaica may have been unclear. That creates a different dilemma. But I'm not sure there is evidence to support that Dominica was unclear, or the WCO was unclear, or Quoted was unclear. Where is the evidence that they were unclear?
Before you answer, let me tell you how I have captured it since I think I started expressing my doubt. I have you in summary as saying, even though Jamaica was misclassifying, it was not wrong because it was thought it was right.
Yeah, and
So,
yeah, sorry.
Without a determination that it was incorrect.
You see, it raises a question which I try to raise with Mr. Hilton. Let's accept what you say, right? So that Jamaica made a good faith effort, but it was mistaken, innocently mistaken. The question for me is whether that would be a good defense in international law. So the nature of the obligation that you have undertaken on the RTC, is it one of strict liability? Is it one of liability which is fault-based? I mean, that's a question I was raising earlier.
I can answer
What say you? Yes.
I could start with your question, and I will get back to the other question. If we consider I think we need to look at two provisions. Let's look at the Vienna Convention. And you made reference to the ILC's draft articles on responsibility for states. Article 1, as I appreciate it from the years when I would have taught it by someone here, it speaks to intentional wrongful acts of the state. So there must be state responsibility for intentional wrongful acts. If we consider the
Sorry, what says that?
it is my appreciation, and I must confess, we were perhaps not prudent enough to provide a submission. But the ILC's draft articles on responsibility of states for internationally wrongful acts.
Yes, it's 2001, right?
2001.
Yes, And where are you quoting from?
Article 1.
Article 1, yes.
There is the reference to intentionally wrongful acts of the state. That is what I understand the test.
Okay. So what does that mean for you? That, well, tell me, what does it mean for you? Sorry.
If you're looking at the issue of, when we're applying our minds to the issue of this breach and the consequences, take a phrase from other areas of the law. What is the measure? What is the intent? Was the intent to deprive, to evade an obligation and violate the spirit of this act, of this treaty? Or was the intention born out of ignorance, which by virtue of disqualification creates a justification or an excuse? And similarly, if we look at the Vienna Convention and the law of treaties, the applicable principles, I believe, are two. Pacta sunt servanda, which may be a double-edged sword in some elements of my submissions, but that's why we've made one concession up front. In Article 26, every treaty in force is binding upon the parties to it and must be performed by them in good faith. It should be interpreted in good faith in accordance with the ordinary meaning given to the terms of the treaty in their context and the object and purpose. That's Article 31, 2. So you look at the preamble, the annexes, and the subsequent agreements between the parties to the treaty.
27 is also relevant, right? Article 27 of the Vienna Convention. But you're not going there.
Not for the moment.
I see.
I would consider focusing on 31 first.
Okay.
Interpreting the treaty provision. Member states shall establish and maintain a common external tariff in respect of all goods that do not qualify for community treatment in accordance with the plans and schedules set out in the relevant determinations of quoted. This treaty is also designed to be dynamic and responsive. We have a situation where the treaty is being followed. Jamaica is applying a tariff code. And for a period of time, in 2018, it is raised first to Jamaica and then to Puerto Rico. Jamaica is applying the wrong tariff. There is not immediately a determination by Puerto to say, yes, it is the wrong tariff. It is not until after Jamaica gets the advice from the WCO that that quoted makes a determination to say, this is how it should be. It's in that context that I asked the court to consider the timing of a breach and whether we have breached the treaty or the termination. An interpretation, I think, what is of emphasis here is deviating from a determination of quoted at a material time. So, to put in context, why is the state's concession so relevant? Because there is no escaping that determination set out particular directive in relation to certificates of origin. Once that had ended, there was no justification for the action. There's no, in that respect, there's no defense to that issue. There can be debate regarding damages and circumstances for consideration, but we cannot deny an escape. In respect of 82, however, whereas the treaty had been of long standing, it had been applied from 2013, if memory serves on the quoted. They had adopted the HS standards from that period of time. But the issue had not been considered. And yes, you have the tariff headings, but there's no explanation, no clear determination. And if it were clear, we wouldn't have had to wait for 2 subsequent meetings for there to be a decision and then a vote. And the fact that all that consideration took place makes it, in my humble submission, a live reason to justify why there was no clarity. It wasn't a but, of course.
I'm getting the impression that you're saying, yes, there was a breach, but it was not a serious breach.
Not a serious breach.
That is the impression that I get. Of course, it was a breach because you applied the wrong classification, but you put it, and I think you put it in the context of saying, well, it was not a deliberate breach, and therefore it was not a serious breach, which you will use later on.
That is the alternative. The first position is that there was no breach
There was
of
no
a determination of quoted by that interpretation. If the court is not with me, then the alternative ground is that in respect of 82, it was not a serious breach because of all the underlying conditions and circumstances.
Although, of course, on the list, or in part 2 of the list of ineligibles, we see soap, organic surface active product, and preparation for use as soap. And it has a heading 34.01.
But no reference to salts or fatty acids in that list, or a reference, which is the name by which soap noodles, soap chips are more technically described. And the reference to other, there is other, a broad category, undefined, unclarified.
So you would say that part 2 of the list is not clear enough to...
It's not clear enough to ascribe liability in those circumstances. And when the clarity was provided, there is now a determination on that aspect of the system, which all can follow, and there can be no debate. Had this been clear, there would be no need for Dominica to have made representations to the extent it did, and Jamaica to have to resort to going to the author of the system applied by quoted to get clarification. It would have been determined from that meeting, it is wrong. Here's the reason why. That's not the evidence. It's not the evidence that it is because quoted gave a directive on that issue that we then complied. We complied once we got the clarification, and that clarification was shared with quoted. It was not shared with the claimant, it was shared at the level of member states. While the claimant is an affected party, it's not a party to the treaty. Okay. So I can, it's on that score that in respect of what, we now turn to the connected relief sought, which is the order for Jamaica to desist from giving exemptions under its PIR regime. My paraphrasing, but I believe we've narrowed the issues enough to not make them plainer. I turn now to the spirit of this treaty. There are 2 sections. Part 1 has a list of ineligibles which do not qualify, and there is room within this treaty for member states to create their own legislation for goods which are not protected. It is accepted that soap is not such an item. It is therefore open to each member state to create a regime, provided it is consistent with quoted, and create a framework that enhances trade and protects its own markets.
Consistent with quoted or consistent with the RTC, primarily, right?
Primarily.
So Mr. Hilton is saying that it is not, the PIR regime was not consistent with the RTC, and he has given his reasons as to why he says that. How do you respond to him?
Respond to him in this way. There is an unfortunate tendency I've found to conflate exportation and importation of goods within the market. What the PRR regime provides an incentive for importation of goods. It doesn't facilitate certificates of origin. It creates a framework where goods that are not protected or outside the list of ineligibles, each state can create a framework to consider a basis when it wants to mobilize particular sectors in its industry to have the ability to get relief from import duties. Part of that test is a determination on whether there is my friend has raised the issue of supply and how we've looked at supply and transformation. The test under the PIR is not substantial transformation. The change in the product to create effectively a value added. And
would you accept that we are concerned based on Article 27 not to be in a convention, not so much with the PIR, but the requirements to be met under the Revised Treaty? Do you accept that?
I accept.
Okay, so really what you need to show us that you're satisfying is the requirements under the Revised Treaty, which do call for substantial transformation. And he relied a lot on Rule 4A of the rules governing the application of a list of conditional duty exemptions. And he's saying the application of Rule 4A results in these soap noodles not being eligible for the exemption. And my question to you is, how do you respond to that argument?
Rule 4A of the rules governing the application of the list of conditional duty exemptions states that where the goods produced by an enterprise do not meet the qualifying conditions set down with respect to those within Schedule 1 of Article 84 of the Revised Treaty, that enterprise will not qualify for exemption from duty with regard to the materials utilized in the production of those goods. When we look at Schedule 1, is an exhaustive list. It ranges from we see in the schedule pasteurized milk, herbal tea, meat of bovine.
It's a long list.
Long list. And I'm giving you these examples. I picked those for a reason.
Yes.
There's no reference to soap.
Correct.
So if you were to apply it in the way that my learned friend is considering, what is the basis to test? Because in the list, you see what happens for MDCs and what happens to LDCs.
Yeah, but the list is not the schedule. That's the point we clarified earlier. This is part of the schedule. So there's a Part B to the schedule. And he's saying that when you apply Part B, soap noodles, chips, do not qualify for the grant of the exemption.
And we disagree. Under part, if you read the sections, Part B flows at Craven budget.
Sure.
The Part 4A and 5 are the considerations that we thought relevant for this court. Part 4B.
You mean rule? Are you talking about the rules? Yeah, Rule 4.
Respect of 4B. And again, 41A has the.
You mean Rule 14A?
1.
Is that where you are? Right. Okay.
1.4.
Yes.
Does the court accept that soap does not fall under that category?
We're not making a determination right now. I think the president said we'll probably reserve.
Yes.
So we
There is no,
we're waiting an argument. Yeah.
if 4A does not apply, 4B cannot. They're not disjunctive.
If you don't come through the door of 4A,
You can't
then
start
you're
over.
not entitled
Sorry,
to grant the waiver to the soap noodles. So how do you come through the door of 4A? Because what Mr. Hilton is saying is that you don't satisfy the conditions set down in Rule 1 4A.
Rule 1 4A, and we're saying that we do. Rule 1 4A is limited.
Is what?
Limited, it does not include, it's limited to the list in the schedule.
Well, sorry, where does it say that? That is limited to the list in the schedule.
Schedule 1, reference to those goods in Schedule 1. That's the qualifying.
So references, you're saying with respect to those goods in Schedule 1 means the good listed in the list to Schedule 1?
That is,
So you're going to insert those words in the rule? Because that's not what it says. It really says to the goods in Schedule 1 of Article 84
or
of the Revised Treaty.
that enterprise will not qualify for exemption from duty with regard to the materials utilized in the production of those goods.
Right.
Any inputs for those goods would not qualify.
Right. Okay. I accept the submission. I'm not necessarily persuaded by it, but I understand what you say. Thank you.
Of course, if those goods do not meet the qualifying conditions, what does that mean? That means that those goods cannot be treated as being of community origin.
And that is limited. That relates to exportation. It wouldn't affect importation of goods. And that is why I say there is a danger in conflating two. It is they need to be disaggregated.
No, but you see, Mr. Stimson, if every state does that, then it affects the exports of every other state, or it has the potential of affecting the exports of every other state.
Your Honor, applying this approach in taking the instant scenario, Jamaica is importing without duty. Jamaican manufacturers are allowed to import soap noodles extra-regionally without duty. In circumstances where soap noodles are not a protected good in CARICOM. And there is a framework that says that unless it is part of listed in ineligibility, you can create a regime that allows this process to operate in relation to importation. It does not.
And that's a purely domestic regime.
Purely domestic regime, which does not in any way create violence to the protections for exports. Because once Jamaican manufacturers are allowed to import in the current state, they get no certificate of origin for their soap.
Not any longer.
Not any longer. Because of the correct applying the determinations and recognizing that it is inappropriate in all circumstances. So where is the prejudice to the party? How does it contravene? We say in those circumstances, both products, one manufactured in Jamaica, one manufactured in Dominica, Trinidad. The Jamaican product is not afforded tariff protections within the region. The Jamaican manufacturers do not only produce for the region. Each territory has built into this system is the promotion of trade, not only intra-regionally, but to boost within each country's capacity.
But there's a common space. You accept that. So there's no Jamaican market or Trinidad market. There's one market.
It's one mark for particular items. What we have here is we have existing brands and emerging brands.
Right?
Major part of this case is not the issue of the competition between the DCPS's soap product versus the Jamaica manufacturer's product, but is the DCP's ability to supply an input for the Jamaican soap market produce,
Which is soap pellets.
which is soap. And so focusing on, if we take the two separately, look at the issue of
Wait, hold on. Is it then that your position is, Jamaica's position is, you know what, look, we import from outside of CARICOM, right? We have the exemption and the PIR, no problem. We're not exporting within the CARICOM market anyways. We just selling in Jamaica and I think you said United States, Canada, whatever. Non-CARICOM third-party countries, right? That's the scenario.
the scenario is that your market is not limited to the region, but within the region, you abide by the treaty.
So you pay the tariff if you want to export,
The good is more expensive than it would be for any entity that would.
and you comply with that,
And you comply with that.
right? Yeah.
And that's the level of the market.
And therefore, in that sense, there's nothing inconsistent
The
with the
protection-
ideology of the market.
The market
You
says-
take the burden and the benefit. The burden being, in your regime, if you export into the CARICOM market, well, your goods more expensive and you compete on those terms.
And because the rules create the ability for non-protected goods
So
to cover domestic regime, like so, there is that benefit to all.
To each, yeah.
So Dominica, DCP, if Dominica established its own, which it is allowed to do, and they import from similar markets, the same process could arise.
I think there's a big distinction between, possibly, a big distinction between the ingredients coming in and Jamaica manufacturing the soap and then exporting all the soap to a third country outside of CARICOM. I'm very interested to hear what CARICOM's response is. But won't you concede that that is one thing on the one hand, and on the other hand, Jamaica's manufacturers importing the materials, making the soap, and then selling in the Jamaican market? Because when you do that, you are depriving the Dominican manufacturer of the protection, if you will, that they get under the CT from being able to export to the Jamaican market.
That's
So
not-
would you agree that there's a distinction between those two things?
If that's an extinction, but that's not the evidence before the court for
That's not the one?
consideration. That's not evidence before the court for consideration.
No, but doesn't it inexorably follow that a manufacturer of soap outside of Jamaica, by reason of that PIR regime, is prejudiced so far as their exports to the Jamaican market? That is why DCPS is complaining.
But I understand DCPS to be complaining about two things. One is the issue of the main issue was its market now going into the market to produce soap pellets for beyond its own demand to sell within the region. And there is
But pause, and in that regard, to benefit for the opportunity in the Jamaican market that wants to consume soap pellets.
And in the Jamaican market, there are two issues. A regime that has been established, which we say is consistent, and a market that has no appetite for its product. That's not the purview of the state. That can't be regulated by CARICOM. That's undergirded in this whole regime is the ability of free movement, free market. There's no one market, so the market forces have to be considered. And we're not looking at Colgate in Dominica. We're looking at a new company, in relative terms, emerging. It may have a plant that can produce 12,000 tons. Its business really is at 1,000. And it's not a case where you see that there is a active evidence of demand for the product. But the structure.
But isn't that a bit
exists-
of a red herring? Because the whole, one of the purposes must be to facilitate new emerging markets. So if DCP wants to get into this business, okay, it's new, but if it can demonstrate it has the capacity to supply the need, I think the question that both the President and Mrs. Anderson have raised remain unanswered, which is the distinction. When you spoke about what the regime involves and the Jamaica, the intersection, there are three intersections, the one with the non-CARICOM third-party countries, the one in Jamaica and in CARICOM, right? Other CARICOM countries. But the Jamaican market is a CARICOM market. So you still have not responded, to my mind.
Okay, let's see.
President asked, yeah.
If we can capture your submission and then we note it and you move on. You suggest that Jamaica, and by extension, therefore, each state has the right to create its own regime that will exempt its producers, manufacturers from the CET, provided that the good which is exempted is not going to be exported to other CARICOM states. It's only for the domestic use of the domestic producers. Does that sum up what you're saying?
In great measure. The only other condition is that the balance to be considered is not limited to what also should factor in, and I believe I did hear Mr. Justice Anderson allude to it in his questions to the claimant, the idea of what a market involves. Is it limited to capacity and limited to supply, to other conditions? And whereas there has been the call of regulating and establishing a regional standard, the regional decision has been to allow the players in the market to determine what they want and what they wish to consider. And
So if we carry this a little further, does the PIR regime, as we just pretty much agreed, it facilitates, would it also continue to facilitate that even if there are regional suppliers of the particular good that can produce in the quantities that Jamaica requires and at an acceptable quality?
no, sir, it would not. Because
So at what stage would that interrogation be done?
so under this regime, it's not static. There's a license granted for, or the exemption is granted, the relief is granted for periods of time, 2 to 3 years, 3 years. There is a review of that. There is a consideration because it must flow from the CET and the treaty. If it is established that there is another that there is supply within the region, and Jamaica were to continue, the PIR would be misapplied.
Okay, so you accept that there can be a point at which the PIR regime becomes invalid, and that point is premised on the ability of regional manufacturers to produce a particular good in the requisite quantities and at an acceptable quality to satisfy Jamaica.
That is,
And so, for your part, it is a question only now in relation to DCPS of determining when that point has been reached.
it's a question of their supply, and supply is twofold: quality and quantity. Is there a willingness in this market for their product?
And you say that in 2023, July, there has not been any proof, it has not been determined Jamaica has not determined that that point has been reached.
I would say it in this way. The timelines are these. Because of the timeline when the relief is granted, if we accept from the decision of quoted in 2021, whatever relief was granted within that time frame will elapse within a specified time.
3 years.
And before that time, so before 3 years from 2021, there will be the need for manufacturers to reapply for this relief. Jamaica must consider as a first step whether there is a regional supply before it can grant the relief.
But is it possible that there are other manufacturers in, other parts of the community who are able to supply in the quantity and the quality desired, and that this happens before 2024?
And if it does, Your Honor, then
Yeah.
it would be because of how a market operates. If a Jamaican manufacturer is aware of let's say local, because local is what local is in within CARICOM.
Yes.
Who can supply to their satisfaction? Why would they opt to source products at greater cost if they are satisfied with the quality?
That's the
cheaper
question.
So
That's
it
the
would be a
question.
greater
Is it greater cost?
It may be the opposite.
That is.
We have no evidence.
price? You have no evidence.
You see, in this, there's the private
No, but
sector
cost is
and the
relevant
state.
this way. If the and again, the issue is application, because whereas under the test, Jamaica Customs must not consider the cost of the item, but the quality, its supply, its ability to meet a demand. When a supplier is going to choose an option, it's going to say, well, I have Malaysia. When I look at that, assuming it doesn't, the right will be this. With a tariff levied on it of 40%, am I willing to pay that versus the cost that may arise locally? And at the end of the day, if that happens, the application will have to exist. But we're not trying to say that this is a preserved market and we're trying to create a protected scenario within the treaty to breach it. What we're saying is at the current time, when it was interrogated, what was provided satisfied Jamaica that there was no adequate quality of goods, because the manufacturers who were seeking it were not satisfied with what was offered.
Yes, I think we understand what you're saying.
So I turn to the second issue. Having conceded that there is a breach of 84, we asked the court to consider the similar test and determine whether this is a serious breach.
But is that for these proceedings? Because we agreed that we would have a separate proceedings on the consequences of any liability that might have been found. And there has been a concession on liability on 84. So it seems to me that this discussion
The
now
issues of,
is-
so the orders that are sought in relation to, so therefore, we have considered more, we didn't look at quantum of damages, but the premise for an entitlement. But if the court, I've heard the utterance twice, so I will on that.
Yeah.
And since the court has also asked to consider, there are just some matters of record that the court should need to, I'd want to clarify for the record. The cross-examination of Shandlin Davis, there was reference to affidavits in the Jamaican proceedings filed by Blue Power, and reference suggestion that Blue Power acted on the advice to use the classification for industrial soap implying that it was a directive by Jamaica Customs. A review of that affidavit, the affidavits will make it clear that that is a confirmed recommend advice from their customs broker, not Jamaica Customs Agency. So it in no way contradicts Ms. Davis's evidence that she is not aware of that classification, and there's no evidence from that party in those proceedings that there is it was a scheme designed by the Jamaican government to evade change.
Sorry, Council, might be me only, but would you mind just going over that ground again? I missed you, I'm sorry.
In the issue of good faith,
Yes.
Fred tackled the matter of how the scheme, the convenience of certain
Events.
facilities within the Jamaican legal framework, and that the PIR appeared to be utilized only when it was confirmed in 2019 that the tariff heading was incorrect. I indicated earlier that the regime existed from as early as 2014.
2014.
Judge Barrow made that interjection, and I provided you with confirmation that it had been utilized from as early as 2016. But when the regime was clear that the tariff heading was not correctly applied, and the utilization was not as a matter of convenience, and there was no other step to evade DET by looking at classifications which would have avoided duty, that application by Blue Power would have been without the direction of or hand of Jamaica Customs. And the affidavit evidence does not infer. My understanding of the questions posed and the submission made is that it would have been facilitated by Jamaica in terms of the directive. And that's not the evidence. It's that it was they were directed to do so by their customs broker. Ms. Davis indicated in her evidence that if that was applied, it would be incorrect. And therefore, there's no inconsistency in her evidence. And the notion of a clandestine rules to circumvent the rules cannot be supported by that evidence. My duty here is to preserve the integrity of our process, whether the court determines the process is right or wrong, but the transparency in how it approached it, and to be as candid as I can in relation to the actions of the state and how we move forward in that determination. Reverend judges. Lordships, I think the only other point to clarify the evidence is the references again in Ms. Davis's evidence to the referral to WCO for advice. And what I wish to indicate to the court with these two important points. One, as previously stated, the WCO would have authored the HS. While Jamaica is a signatory to quoted, it is still not a signatory to the HS agreement.
It is not.
It is not. So when the references in that table set out conditions of administrators and conflicts, if on the face of the document, it goes beyond a reference only to that. It sets out exactly what is to be considered. It set out the 3 different tariff headings for advice. And because it is not currently, it will be. My instructions are that we will become a signatory in short order possibly, but certainly not in 2018, 2019, 2020, or 2021. So at that time, the nomenclature there, if erroneous, accepted in one part, matters of interpretation don't change the substance of what was represented. The facts are represented truthfully and candidly. Give us your interpretation of these 3 provisions and tell us which one certain rules fall under. I hope the court will not take offense to my simplification or paraphrasing of what it really means. And that was what was sought, and the evidence makes that clear. And that's why I needed to correct the submissions in our written documents to the court. It didn't say all had merit. It considered all 3. Why? Not because it was in a vacuum, but because it was provided and asked for. And so at that juncture, the obligation of Jamaica Customs is not to consult or refer to what DCP or the State of Dominica has asked. Jamaica is clarifying a position for itself, which it then presents to court and a determination is made. So we urge the court to appreciate the form of the representation, the substance of the representation, and not be constrained in any way by what impressions or inferences could be drawn to parts of the form in how it was presented. Given the state's position, unless I can be of any further assistance to the court, yield again this.
Of course.
I'm guided by my instructing counsel, instructs me very well. She's more seasoned this year than I. The other matter I think that has been loomed large enough for the court is the matter of consultation and how that falls into the theme of the. So I'm indebted to Ms. Neal for her assistance. We're not accustomed to being so far from each other in other jurisdictions, but I am, and this desk can't hold all of the bundles. The DCP was not operational. We say that, again, we must consider the chronology is important. Context is key. The issue of consultation must be seen in the parameters, not today, when DCP has given evidence of what it can currently produce, but in the consideration of the time frame prior to the court decision and leading up to it.
Could we, I know, I don't want to detain you very long, but could we just get to the principle first before we get to, yeah. So in principle, are you conceding that there was an obligation on Jamaica to consult with DCP, with quoted, and
I think
so
it
on?
has a duty to consult with quoted and notify quoted of the decision.
You're conceding it had a duty to consult with quoted and to notify, you say?
And to, I didn't hear
And
you.
to, sorry, you said, and to notify quoted of its decisions? Did you say that? That might be more efficient, I think.
I crave your indulgence.
Second chair.
So under the PR regime, what is incumbent is notification, and that would have been given to quoted of the establishment of the regime.
Which is different from consultation, of course. It's
Yes,
notification, right?
because the my lord, Your Honor, Justice Anderson, you made reference to the committee that is established regionally, the Q.
Cross-Q?
Cross-Q.
Yes.
Cross-Q comprises members of various customs heads within CARICOM.
Yes.
So it's not, it's really a situation where there is a regional determination, a standard by consultation of the very same parties. I think Ms. Davis becomes Jamaica's representative
quite
on that.
likely, yes.
On that. So there again is no siloed activity. There is within the scheme that once we are satisfied that this regime falls within our framework, proceed. Now, has that been questioned by?
But no, that's the principle once again. So you say, yes, principal consultation with Cross-Q, but that's done almost automatically because the Jamaican representative is on.
And under the regime.
Okay. What about with quoted, the same thing? Same idea? Because you have a representative on quoted, so it's brought to the attention of quoted, discussing quoted?
It's there in the same way because the same parties exist and have these meetings.
What about DCPS?
At the material time when 2014 DCPS did not exist?
Yes, but subsequent to that, when they did exist and they did show an interest in supplying the Jamaican market, was there an obligation in principle to consult with them?
To consult with DCPS under the PR issue of supply. There is a duty to determine whether there is an adequate supply within the region.
Who is that duty on? The Jamaican authority?
Jamaica Customs has to satisfy itself, and within the framework, there is no explicit obligation because it will consult with its importers and say, well, what is here, what's available. There is knowledge that there were importations from DCPS that were not satisfactory. Or I would say the words used in evidence, they were not accepted. That was my question to Mr. Nelson. They were not accepted by the local manufacturer.
I recall.
It's a different threshold from a safeguard application, where what must be considered is the adequacy of supply under the RTC and relevance and an evaluation by quoted as to a position as to what is reasonable in the region. Within the purpose
I don't want to mislead myself. I just want to get in principle whether you concede that there was an obligation to consult with the CPS. That's all.
no obligation to consult with
You had no obligation to consult.
not in the circumstances.
That's very clear. Thanks.
And there's no duty in the CET regime to consult regarding domestic exemption.
Yeah, sorry.
There's no duty under the CET to consult regarding domestic regimes. What must be satisfied is notification and the determination that there is the provision not inconsistent. If they're inconsistent, then it would be invalid.
Yeah.
So in respect of this matter, what we say is that if the court does not accept that the decision by Jamaica Customs was correct, there was a misapplication of the PIR, and not that the regime itself is invalid. Because based on the framework, there are material considerations that, if satisfied, will not do prejudice to the RTC.
Okay.
And to that extent, we will rest if there are no further questions.
Okay, thank you very much, Mr. Simpson. We take a break at this point and we come back, try to come back at 2.
All right.
All rise. President, judges, the Supreme Court of Justice.
Yes, CARICOM, Ms. Showman, or
Thank you, Your Honors. This afternoon, we are asking Dr. Chantal Onanairu to present the position on behalf of CARICOM.
yes, thank you.
Good afternoon, Your Honors.
Yes.
The community will seek to provide assistance as amicus curiae to the court with respect to the particular questions that the court would have sought the community's responses to, but we will also use the opportunity to provide some views or perspectives on related matters that have arisen during the course of the hearing. The court would have asked the community to provide responses to a number of questions that concern the conditional duty exemption regime under the CET, as well as a number of questions relating to the community rules of origin, in particular with respect to the safeguard mechanism of those rules. The community will commence with providing some perspectives on the conditional duty exemption regime under the CET. The court would have asked the community to provide its views on the circumstances in which a member state would be able to exempt unilaterally extra-regional inputs from imposition of the CET. In our submissions, we would have highlighted three circumstances or three conditions that would need to be satisfied under the conditional duty exemption rules for a member state to unilaterally exempt extra-regional inputs from the imposition of the CET. Your Honors, all three conditions or circumstances appear to be live issues in this case. The first condition highlighted was that the inputs are items which, when imported for the purposes stated in the list of conditional duty exemptions, are eligible for duty exemption. And in this regard, we would have reiterated that the list of conditional duty exemptions sets out particular goods which, when imported for particular purposes that are specified or in particular circumstances, could be exempted. We've noted the relevance in this case of the circumstance where the imports are brought in for, are materials that are imported for approved industry. And we would simply highlight the fact that the term industry is not defined in the conditional duty exemption regime. And so it will be important for the court to provide some clarity on the scope of this term, particularly as a particular reading has been advanced by one of the parties as being limited to manufacturing activities using raw materials. We also would wish to stress that the list of ineligibles embodies the principle that member states should source from within the region those goods which are available. This is a principle, this principle of source first from within. It is a principle which the court has already highlighted as being relevant or underpinning the regime for suspension of the CET. The court would have affirmed this in the case of TCL and CARICOM, but the community also observes this principle with respect to the operation of the safeguard mechanism, which we will address shortly. We would also want to reiterate that where items are on part 1 of the list of ineligibles, they're not eligible for duty exemption or reduction if they're imported for use in industry, agriculture, forestry, fisheries, and mining, except in limited circumstances, which we have reiterated in paragraph 6 of our written submissions. Additionally, when items are set out in parts 1 and 2 of the list of ineligibles, they're not eligible for duty exemption or reduction when they're imported for other approved purposes. Again, unless certain conditions are satisfied, for instance, if the items are gifts. So we would reiterate that soap appears on part 2 of the list of ineligibles and could be imported. Inputs that are used in the production of soap could be imported duty-free if they are imported for use in industry. We would also wish to highlight the importance of Rule 4, a matter on which there have been a number of questions raised during the course of the hearing. And here, Your Honors, we would want to pay close attention to the actual language used in Rule 4A to begin with. This provision provides that where the goods produced by an enterprise do not meet, and I quote, the qualifying conditions set down with respect to those goods in Schedule 1 of Article 84 of the treaty, the Revised Treaty, the enterprise will not qualify for exemption from duty with regard to the materials utilized in the production of those goods. This would seem to suggest that Rule 4A does not allow for duty exemption for extra-regional materials where they are used in the production of goods that, quote, do not meet the qualifying conditions set down with respect to those goods in Schedule 1. We would point out that Schedule 1, with respect to Part A of that schedule, and that is the list of conditions to be complied with in order for products to meet the qualifying conditions under Article 84, they do specify conditions that the goods appearing in that list have to comply with in order to obtain originating status. And so it is very possible for the words qualifying conditions set down with respect to those goods in Schedule 1 to be interpreted as the qualifying conditions which goods which appear on the list in Schedule 1 would have to meet. We have taken note that a potentially broader understanding of the reference to Schedule 1 could be adopted. That is where the reference is not only to the list of conditions to be complied with, but also the rules regarding community origin in Part B of the schedule. We would, however, request the court to consider whether the rules regarding community origin, which are specified in Part B of the schedule, actually do represent qualifying conditions which are set down with respect to goods in Schedule 1. One could read Part B of the schedule as essentially specifying, essentially laying down rules that clarify how the qualifying conditions should be interpreted. Qualifying conditions such as wholly produced, which is defined in Rule 2, or even the understanding of how the requirement of substantial transformation should be read. And so one could look at Rule 1.5 of Part B as specifying the kinds of minimal processes that are insufficient to amount to substantial transformation, even if there is a change of tariff heading. This may not necessarily represent a qualifying condition with which goods would have to satisfy in order to obtain community origin.
Dr. Anamaru,
Yes,
may I ask
Your Honor.
you, please, whether you have, or the community, or the Office of General Counsel has a view on this matter?
Your Honor, we do think that there is significance to the words qualifying conditions set down with respect to those goods in Schedule 1. The words qualifying conditions, particularly if one looks at the explanatory booklet published by the Caribbean community in 1992, which is one of the documents appended to the community's written submissions, that document uses the term qualifying conditions in particular circumstances. So for instance, when the booklet recounts what the general qualifying conditions under the rules of origin are, it uses the term in relation to wholly produced, and it also uses the term in relation to substantial transformation. There are also references in that booklet to the words qualifying conditions when speaking to the particular conditions that must be complied with as specified in the list in Schedule 1. And so I think there must be some context, that the words qualifying conditions must be read in context in the way that the community's rules of origin have used that term. And particularly because Rule 4A uses the terms qualifying conditions set down with respect to those goods in Schedule 1. That may point to qualifying conditions that are set out in Schedule 1 for particular goods. And that really is only done in the list in Schedule 1. Part B of the rules regarding community origin could be understood to be rules which provide an understanding or interpretation of how the qualifying conditions should be understood. The implication of reading Rule 4A in this way is that, of course, it would beg the question, what rule, if any, would apply in circumstances where goods which are not specified on the list in Schedule 1, what would obtain if those goods do not meet, to be specific, the wholly produced rule or the change of tariff heading rule, because those would be the qualifying conditions that apply with respect to goods that do not appear on Schedule 1. In the list, I should say, in Schedule 1. And so the question is, in the case of a product like soap, which does not appear in the list in Schedule 1, and in respect of which the qualifying conditions would be wholly produced or substantial transformation, what would be the implications of there being no specific rule laid down for such goods? That is really a question I think the court, if it is persuaded to read the words qualifying conditions in Rule 4A in that way, would have to grapple with. What was the intention? Was the intention that if a good is not specified in the list in Schedule 1, is the understanding that the inputs used in the production of the good which does not qualify for community origin would be exempt or not exempt from the CET? This is an important issue we're submitting for the court to attend to, because if Rule 4A, if the words qualifying conditions are interpreted that way in Rule 4A, then the absence of an explicit rule applying to goods that don't appear on the list would be something that the court, I think, would have to address its mind to.
Dr. Ananaru, could this not be read as, let's say, goods who are not the results of a substantial transformation?
Well, one must, Justice, Your Honor, if I am interpreting your question correctly, you are asking if the words qualifying conditions should be understood to only mean substantial transformation? I just want to make sure I understand your question correctly.
That is one if the good doesn't meet qualifying conditions. That would be one way of saying that the goods were not the result of a substantial transformation and therefore could not afford it community origin. So if you take it in that way, then my question is, couldn't this be read more broadly as saying, well, goods that are not the result of a substantial transformation, for example, because the materials they were made from are in the same heading, tariff heading, could that not imply that as a bottom line, so to speak?
Your Honor, the only reason that interpretation would give me pause is because there are a range of qualifying conditions set down with respect to goods in the list to Schedule 1. And those qualifying conditions do not only relate to substantial transformation. For instance, there are products specified in the list in Schedule 1 where the qualifying condition is wholly produced. There are also goods set down in the list in Schedule 1 where the particular way in which substantial transformation may be achieved may not relate to a change of tariff heading. It may be a process rule. It may be a value-added rule. It may be a requirement to use specific regional materials. And so I think to only understand the reference to qualifying conditions in the list to Schedule 1 as relating to not having substantial transformation achieved would in essence ignore the other types of qualifying conditions which are sometimes prescribed in the list in Schedule 1, such as the requirement of wholly produced.
Yeah, so you say that it's not likely to be limited to substantial transformation, but could it include them?
It could include any rule prescribed for a product in the list entailing substantial transformation based on the means through which substantial transformation is specified for that product. Because the list in Schedule 1 prescribes essentially one route through which the good in question can qualify as being of community origin.
Correct.
So if the rule is specified as a process rule, that is the only means of substantial transformation which can be achieved by that product when specified in the list.
Okay, thank you.
Can you sketch for us a little bit more the consequences of interpreting Rule 14A as referencing only the goods listed in the list to Schedule 1 of Article 84?
One consequence could be that there's a lack of clarity as to whether a member state is allowed to unilaterally exempt an input used in the production of a good that doesn't appear on the list and does not meet the qualifying conditions. If a rule does not appear on the list, the qualifying conditions for that rule would be wholly produced or change of tariff heading. The consequence of reading the words qualifying conditions as only relating to the conditions to be complied with for products in List 1 is that there could be uncertainty as to whether the rule laid down in Rule 4A applies to goods that do not appear on the list. And so, for instance, we could be faced with a scenario where a good doesn't appear on the list. It is subject to the wholly produced qualifying condition or the change of tariff heading qualifying condition. The good, for instance, may not meet either of those two qualifying conditions, but there may have been a desire on the part of the member states to exempt the input from the imposition of the CET. If Rule 4A is read narrowly to relate to only those products that appear on the list, there may be lack of clarity as to whether a member state is allowed to or not allowed to impose this, exempt the imposition of the CET on the input used in the final product that did not qualify as being of community origin.
But if it's read in that way, there isn't any lack of clarity, surely. It's read in a very narrow way. And therefore, what I'm trying to get from you is what would be the implications for intra-regional trade if it was read in that way?
If it was read in that way, and it was understood that goods not appearing on the list, when they don't qualify as being of community origin, their inputs could be exempted from the imposition of the CET, it would mean that those goods could enter, well, they wouldn't enter intra-regional trade duty-free because those goods wouldn't qualify as being of community origin. But what would happen is that their inputs, if you read the provision in that way, would not, a member state could exempt the inputs from the application of the CET, but any good that doesn't qualify as being of community origin cannot enter intra-regional trade subject to preferential treatment.
Yes, but the point is that if the good then gets into a market, into a jurisdiction that represents 50% of the market for a particular product, wouldn't that distort the whole objective of having a single space where manufacturers from around the region are allowed to manufacture their products and to sell within one single space?
Your Honor, if I understand your question, in that scenario, the good, when it enters the single space, would not be entering duty-free because it would not have met the community's rules of origin, whatever the applicable rule is, whether it was wholly produced or change of tariff heading. If the good does not qualify as being of community origin, it would not enter the single space duty-free. However, it is possible that the input might have been exempted from the application of the CET. And so the question is, would you have some kind of, for want of a better word, I don't know, competitive advantage or disadvantage ensuing because the good doesn't qualify as being of community origin, but the input itself is exempt from the application of the input. Now, I understand, Your Honor, if we were looking at the specific case before us of soap.
Yes.
Again, I'm assuming that what we would be dealing with is a good entering the domestic market in question.
Yes, yes.
It's not being exported, and so it's entering a domestic market, and so there's no question of the application of a tariff because it's entering the domestic market. So that good would be entering the domestic market in circumstances where it's the inputs used to produce that good might have been exempted from the CET.
Yes.
I guess that's a possibility, but I guess the question is whether that's really what Rule 4A is dealing with, because Rule 4A is dealing with the scenario where a good actually has to qualify as being of community origin, which really only comes into play if the good is consigned to another member state. If we go back to Article 84, Article 84 sets these requirements for origin for goods in circumstances where they're consigned from one member state to another member state. So if the good is entering, and I hesitate to use the word domestic market because we're speaking of a single market, but if the good is not consigned to a consignee in another member state, I don't know that the question of certification of origin even arises, which is really what Rule 4A is dealing with. What do you do in circumstances where the input You're seeking to exempt an input that has been used in the production of a good, which is clearly destined for other member states, and therefore the question of whether that good qualifies as being of community origin is relevant.
So, Dr. Ono,
But I hope I'm not
can I just,
oh, I'm sorry.
just for me to understand, so that if the input is being used to produce a good in Jamaica, and the good produced is remaining in Jamaica or being used in non-CARICOM, exported to non-CARICOM third-party states, so it's being used in Jamaica, are you saying that Rule 4A may not be applicable? Is that what you're saying? Because Rule 4A is and Article 84 are dealing with goods that are eventually finding their destination in other member states. And if so, isn't Jamaica a member state? So that you're bringing an input to produce a good in Jamaica that is being sold in Jamaica.
Your Honor, you're correct that you're dealing with a scenario where the input would be used to produce a good that is being sold in the same member state producing the good. But what I'm trying to point out is that the scenario addressed by Rule 4A simply wouldn't arise, because if a good is being produced by a member state and sold in that member state, there's no question of having to comply with any qualifying conditions for community origin, because those qualifying conditions only come into play when you're dealing with goods that are directly consigned from one member state to another, and those goods are seeking community origin treatment, which would result in their exemption from duty. So I'm being guided by the language in Article 84, which makes it clear that a requirement for community origin treatment is the consignment of a good from one member state to a consignee in another member state. And so if the goods remain in the member state of production, there's no such consignment. And there would be no need for obtaining a certificate of origin.
Dr. Ananayo, just to be clear, I'm reading now from the amicus curiae submissions of CARICOM, paragraph 16, little terse paragraph. Even if the soap noodles could have been exempted under industry on the basis that it is listed on part 2 of the list of ineligibles, Rule 4A would exclude soap noodles from being considered for exemption, as the finished product would not qualify for community origin treatment. Is that something you would maintain in this form, or would you nuance that?
We are asking for that submission to be nuanced because of the importance of reading the words qualifying conditions set down with respect to those goods in Schedule 1 in a coherent way. And as a matter of fact, the submissions which the community most recently made and which sought to respond to the court's questions concerning the safeguard mechanism really did go to some length, particularly through citing the relevant publications of the Secretariat, which we think are important to a reading of the community rules of origin to explain what the words qualifying conditions mean. And so we are putting this before the court so that we can be as of complete assistance to the court as we can be with respect to the issues with which the court has to grapple in fully appreciating the structure and operation of the conditional duty exemption regime of CARICOM.
Thank you.
Doctor, I want to ask you the risk that you see if the court, for example, agrees with what I understood for you to be saying at the beginning, which was that if qualifying conditions are referring to only those goods listed, then what is the risk to each member state setting up a regime that is so very different one from the other? Would there be, I suppose that is why you said to us that even if that is the interpretation we give to 4A, we should still consider, I take it, if there's a threshold, if there are other conditions, if there are broad factors under the RTC that should be applied. How do you see that could amount to a risk and impact this single space that my brother Justice Anderson keeps speaking of?
Thank you for that question, Your Honor. It really points to the range of considerations that the court will have to weigh and balance in understanding how this provision should be interpreted. You did speak of the question of risk, and I think what really needs to be reflected upon is what would be the consequences of allowing a member state to exempt from duty inputs that are used in the production of goods that aren't on the list that don't meet the community rules of origin. So we're not talking about goods that are on the list. We're talking about once a good is not on the list, it has to meet the criterion of wholly produced or change of tariff heading. So if we have a product that is faced with that qualifying condition, it has used, an input has been imported to be used in its production, and the input does not, and the input, the member state wishes to exempt that input from the application of the CET. If the product in question doesn't meet the qualifying conditions, it cannot enter trade within the region duty-free. And so really what we would be reflecting on is, do we see any kind of risk that would ensue from the member state in those circumstances being allowed to exempt the input from the application of the CET? The good cannot enter intra-regional trade duty-free because it would not qualify as being of community origin by virtue of satisfying the wholly produced or change of tariff heading criterion. And so it is really for the court to assess whether there is perceived to be a risk if the member state is allowed to exempt the input from the application of the CET.
In this question, Dr. Ononero, would there be some form of imbalance or I don't want to use the word unfairness, but let's just say imbalance, where a particular the country that does this exemption has a tremendous market as compared with another member state whose market is so small that its producers can only export in order for them to be profitable, in order for them to be feasible. And so effectively, that interpretation deprives or makes it more difficult for that latter member state to trade freely in the former member state. Would that be a consideration?
So I'm thinking through your question, Your Honor, and I am trying to compare the situation where the two member states in question are producing the same final good. Because I think you would have to be looking at that kind of scenario to undertake a fair comparison. So assuming that the two member states are producing the same final good,
right.
One has a large, I hesitate to use the word, but let's just call it domestic market, and its manufacturers are given relief from the application of the CET, with respect to the inputs used to produce that final good that is sold on the domestic market, which is a large market, compared to a producer, a manufacturer from a sister CARICOM member state, which is a smaller economy. I guess seeking to do the same thing. I'm seeking clarity here, President. This is clearly a company that would be looking to export, I'm assuming, because as you said, its domestic market is small. Domestic market is small.
Right, but they,
Again,
they
the same
do
rule
not
is
have a
applying.
regime, or they do not apply.
But they don't have a regime for exempt, right? Well, the regime is open to them, though. It's not as if the rules would preclude that member state from operating a regime if it wanted to. Again, the rules would not be only allowing the larger member state to operate that regime and the smaller one not to. But let's assume we're comparing one that doesn't operate the regime, the smaller country doesn't operate the regime, the larger economy operates the regime. There could be a competitive disadvantage, particularly if the manufacturer based in the smaller member state is looking to export the final product to that larger member state. But again, if we're comparing apples and apples, we would be comparing a situation where I'm assuming in both scenarios the goods don't qualify for community origin treatment. Because if you're comparing a scenario where the smaller manufacturer is producing a good that qualifies for community origin treatment, when they're exporting it, it's going into the other market duty-free. They may not be exempt with respect to the input, but their final product is entering duty-free. I'm assuming that their good qualifies for community origin treatment. It would be exported duty-free. The other market, the other manufacturer is based in a larger market, receives an exemption from the input, doesn't export to the rest of the region, but a lot of what it exports is then on the domestic market. The question really would be, would there be any kind of distortion of competition that is arising by virtue of the availability of the exemption to the manufacturer in the larger market, which the manufacturer from the smaller member state isn't enjoying, but is they're allowed to export what they are manufacturing to the other member state duty-free, provided it qualifies as being of community origin.
And that would involve another regime altogether, which has not been invoked in these proceedings. Would you agree?
That would be Chapter 8 of the Revised Treaty.
Okay.
And that's assuming that the actions would have anti-competitive, cross-border anti-competitive effects.
You've spoken at length about 4. I wanted to ask a question about 5, Rule 5. So you're saying that 4 is not relevant because it deals with where goods are consigned from one member state to another. So in those circumstances, that 4A becomes irrelevant. 5 though, 5 apparently, and correct me if I'm wrong, it seems to allow, certainly one of the parties here argues, it seems to allow a member state to unilaterally devise a regime under which the member state allows a waiver of the CET on inputs into a good that is to be produced in that member state. Manufactured, produced, there are differences of language there. Would you agree that Rule 5 allows for that possibility?
Rule 5 allows for materials. Well, Rule 5 is really concerned with products that are on the list of ineligibles. So again, it all depends on where the products appear. So if we're talking about products that appear on Part 1 of the list,
well, sorry, specifically we're talking about a product which does not appear on Part 1, but appears on Part 2.
Right. So with respect to a product that appears on Part 2 of the list, like soap, then it could be the imports that are used could be exempted when they are used in industry. Approved industry. Again, a term which is not defined. And approved industry there.
Sorry, just in the way I know, but approved by whom? Can you say? Is that by the community or by the member state?
I think it would be by the
member state.
I think it would be by the member state seeking to exercise the discretion.
Okay.
Because that member state also has the flexibility under the conditional duty exemption regime to define the beneficiaries of the exemption.
Got you. Thank you. I know we have into your time, but I think that these 2 points are obviously the ones that have drawn our attention significantly. So don't worry that we have exceeded, please.
Okay. Your Honors, I would just end the submissions of the community on the conditional duty exemption regime by just reiterating that Rule 4B, that Rule 4B prescribes that Rule 4A that we just discussed would not apply to goods that are produced for export to third countries. So again, this not allowing for the exemption on the inputs is not applicable if the goods are being produced for export to third countries. We also would just want to reiterate, because some of these points would have come up in submissions and in evidence, that there really is no need to seek a CET suspension if a unilateral exemption is possible under the conditional list of duty exemptions. A CET suspension would be sought if a unilateral exemption is precluded, for instance, in a scenario where an input on Part 1 of the list of ineligibles is being sought for use in industry. In those circumstances, the member state would have to seek an exemption, have to seek a suspension of the CET and come within the grounds that are available for a suspension. We would also just wish to briefly highlight that it is not the community's understanding that there is any requirement or obligation of a member state to consult.
Sorry to interrupt you, but you just said no need to seek a suspension of the CET if a unilateral exemption is available. Can I just ask you, for example, under Rule 5, is that what you mean? For example, under Rule 5, if used in industry and approved by the member state.
Yes, Your Honor. So, for instance, if the member state is trying to secure an exemption of a departure from the CET with respect to, for instance, a product that appears on the list of ineligibles, and there is no way the unilateral regime or the conditional duty exemption regime would allow for the exemption of the CET on a product appearing on the list of ineligibles, the only option would have to be to seek a suspension of the CET if the member state wants to have a departure from the CET.
Thank you.
You're welcome, Your Honor. And just to highlight that the community, there's no real practice in the community of a member state having to undergo consultations before it invokes the discretion to unilaterally exempt products from the imposition of the CET. We would highlight, though, that the community has pointed out the need in the interest of transparency and to allow the quoted to fulfill its function to oversee the operation of the CET, that there be notification to the quoted of any such exercise of the discretion.
That's a important point. Could we stick a pin right there? So you are saying that from the community's point of view, there is no obligation on the member state to consult before invoking the discretion on the Rule 5?
We're saying there hasn't been a practice of that, Your Honor. We're just pointing out for the court's information or attention that what member states have been advised to do, given the quoted's role in overseeing the operation of the CET, is to notify the exercise of the discretion so that there's full transparency with respect to its exercise. Because at the end of the day, there is also an obligation to ensure that when that discretion is exercised, it's exercised in conformity with the rules that govern the application of the conditional duty exemption regime. and the notification obligation facilitates that scrutiny of whether the way in which the member state has actually exercised its discretion is consistent with the conditional duty exemption regime.
Thank you.
Your Honor, I would be guided by the court as to whether the community, the extent to which the community in its oral submissions should address the remaining 4 questions that would have been put to the court. We do not wish to repeat in detail all of what is in our written submissions. We would just wish to highlight certain points for the court's attention. With respect to the second question that was posed to the community relating to the circumstances that would necessitate an application for a safeguard certificate under Schedule 3, our submission stressed that under the safeguard mechanism available under the community rules of origin, this is really a mechanism that is meant to apply in very circumscribed circumstances. In particular, we would stress for the reasons outlined in paragraphs 8 through to 19 of our most recent submissions that the safeguard mechanism is only meant to apply in circumstances where the final product being made, or the product being produced, I should say, the good being produced, is on the list in Schedule 1 and is subject to the qualifying condition for community of origin of wholly produced or produced from regional materials. The safeguard mechanism was essentially designed to ensure that where essentially a manufacturer or a producer of a good is subject to a qualifying condition that requires the use of regional materials, that producer should not be placed in a position where, due to the unavailability or inadequacy of the regional supply of that regional material, there is an inability to meet the qualifying conditions of the rules of origin. For the reasons that we've outlined in our written submissions, the safeguard mechanism is not meant to apply to circumstances where the good being produced can qualify through essentially a route that doesn't require the use of regional materials. As we have indicated, where a good doesn't appear on the list, it would qualify through either a change of tariff heading or through meeting the wholly produced criterion. Given that the change of tariff heading qualifying condition allows for the use of extra regional materials in the production of the good, there really would be no need to invoke the safeguard mechanism in those circumstances. And we have elaborated in our written submissions as to why we have put forward that view. We would also just wish to speak to the question that has arisen in a number of ways about the question of demonstrating whether the quality of the goods required by the manufacturer has been satisfied. What we would stress is that, particularly where questions concerning compliance with qualifying conditions that require the use of regional materials is concerned. And as we said, this is what obtains with the safeguard mechanism. This is what obtains where a manufacturer is seeking to obtain regional materials to meet the wholly produced criterion, for instance. This question of whether there is an availability of the quantity of regional materials required according to the quality, and I'm using that, the community has used that term specifically, required by the manufacturer. It's really pointing, in our view, to the question of whether the available regional materials meet the product specifications of the manufacturer. There have been questions about what is the role of regional standards, such as regional standards that might be adopted by the COTED based on the recommendation of cross-skew? What is the role of regional standards in assessing the adequacy of regional supply to meet the requirements of the manufacturer? In our view, it should be recalled that a regional standard is voluntary. It essentially sets the floor beyond which the standard shouldn't fall. But it doesn't preclude a manufacturer from opting to go beyond the requirements of the regional standard for reasons that have been elaborated in witness testimony yesterday, in evidence yesterday. And so if one were to only use what is prescribed or proposed by a regional standard as the reference, essentially what would be happening is that manufacturers, notwithstanding whatever specifications they would want to develop to distinguish what they're producing in the marketplace, they would be bound by whatever specifications follow from a regional standard. And so where what is being assessed is really whether the manufacturer is able to obtain the inputs meeting the specifications it needs in order to produce the product that it wishes to put to market, whether that's met. That, in our view, is an assessment of whether the available regional materials meet the product specifications of the manufacturer. That doesn't place the issue of quality into the realm of subjectivity, some subjective understanding of quality, because there is an objective reference point that can be used to establish whether the regionally available product meets what the manufacturer has objectively put forward as its specifications. The final point that we would just want to reiterate is just to clarify that the Customs Committee of CARICOM considers and makes recommendations to the quoted on matters concerning the tariff classification of products. And again, this allows the quoted to discharge its role with respect to the operation of the CET under the revised treaty. We just provided that clarification because there were at times references to referral of the matter to a regional body, and we just wanted to clarify the role that is in fact played by the Customs Committee as a body which makes recommendations to the quoted. With those submissions, Your Honours, the community would rest unless there are any other matters on which the community could be of assistance.
I have one other question. I think schedules 1 to 4 clearly are part of the treaty, is that so?
Yes, they are.
Yes.
Your Honour.
For example, what is the legal status of this list of conditional duty exemptions? How do I have to understand that? That's not really part of the treaty, you know? Is it a decision of quotas, or how do I have to see that?
So, Your Honour, if we were to refer to Article 82 of the treaty, Article 82 makes it clear that the member state shall establish and maintain a common external tariff in respect of all goods which do not qualify for community treatment in accordance with plans and schedules set out in the relevant determinations of quoted. And the full text of the revised Common External Tariff of CARICOM based on HS 2017 is available on the website of the community, and it does reflect the relevant determinations that have been made by quoted. We would just want to point out that the community rules of origin and the CARICOM CET pursuant to paragraph 5 of article, well, not paragraph 5, pursuant to article 83 are under review. And so it, pursuant to articles 83 in the case of the Common External Tariff and article 84 in the case of the rules of origin. And again, when that review process is complete, it will result in an update to both trade policy instruments.
Thank you.
Yeah, thank you, Dr. Onanairo. Mr. Hilton, how long do you think you would be?
You know, the points I intended to make would not be more than 5 hours.
Yes.
Your Honor, this morning, Sir Justice Anderson had drawn my attention to Article 31 of the Vienna Convention.
Sorry, I don't think I mentioned a particular article, but yeah, I think your colleague opposite mentioned 31.
I see.
Yeah.
Okay, I thought you had referred me to the fact that the treaty referred to the good faith.
Yes, I think that's 26, Article 26, and 27, I think might be relevant as well. 31, I think, deals with interpretation. I think Mr. Stimpson, the one who...
Stimpson raised. Well, in relation to that interpretation provision, I just say, Your Honor, that raises the issue of good faith in the context of interpretation, and means nothing more than this court had observed in the Rockhard case, which is that you cannot just look at the words of the provision, you need to look at the context and surrounding circumstances and so on. But good faith is not being used by the defendant in this case for that purpose. This is not a situation where they're saying if you use that approach, the interpretation of a provision or obligation should be any different. They're saying, in effect, that even if they breached an obligation, because they did so in good faith, that's a defense, which is not at all what they what the convention envisages or speaks to. And I would also say, Your Honor, that while the good faith interpretation approach can widen one's obligation, so you have an obligation not to just comply with the strict obligation, but also do so in good faith, it doesn't lessen your obligation.
Yeah.
If I may go on, Your Honors, Council conceded at the start of the submissions that Jamaica had breached Article 84 from 2021 when quoted issued this decision, but was not in breach prior to that. If I may just make two observations in relation to that submission. The first is that the Jamaica accepted from 2019, I think, following the WCO guidance, that they were wrong in the misclassification. And Your Honors will find at Bundle 4A, page 87, a formal concession in that regard, so that even if one were to follow my learned friend's reasoning, the concession he made ought to run from that, not just from quoted in the following year. But also, in both cases, it would apply to both 82 and 84. There's no reason to limit it to one and not the other. But the more fundamental point is, in either case, there was merely an indication or a confirmation of the position. It didn't change the position. It's not a case where it was not wrong before and it becomes wrong because of what was agreed at the quoted meeting. It's similar to a situation where a court makes a decision, it merely is declaring the position, it is not changing the position. And I'd say for completeness, Your Honors, if one looks at the savings grant in relation to that quoted decision, it actually says member states are reminded, not deciding, announcing a decision. The decision is to remind member states of an obligation. And for completeness, that is at Bundle 4A, page 156. So, Your Honor, those are the issues I plan to address in response.
But Mr. Hilton, how do you respond to the bombshell suggestion about how to interpret Rule 4A, and which apparently it seems that the Office of General Counsel, at the very least, is leaving open as a possibility.
Well, Your Honor, I appreciate, we respectfully don't agree.
Mm.
We respectfully do not agree. In the community's original submissions, they took a position, and indeed, Sir Justice Witt drew attention to paragraph 16. That's a position that we consider correct. Counsel has indicated, I think her words were
Nuance.
a more nuanced.
Yes.
Perhaps a stronger word than that should have been used.
Yes.
But Your Honor, if you have, first of all, if you have separate interpretations, different interpretations, and one is more consistent with the purpose and intent of the treaty, that one ought to be preferred. I'll start there. But the question of inconsistency between what's in the schedules and what's in these rules, so that Schedule 3, paragraph 18 and 19, we speak specifically to oils and fats not being exempted. We don't know if you take precedence in any event. As Justice Witt pointed out, these are part of the treaty. So I would respond to CARICOM in that way.
And any response to the question of consultation, which again...
Yes, Your Honor. Well, we stand by the submission that my team had made, that if you are carrying out there is clearly a duty under Article 20 on CARICOM to consult. And if there is effectively a delegation of that power, there ought to be that duty to consult on the member state or the person carrying out the function as well.
Duty to consult with whom?
With CARICOM, which was the specific point I think was being addressed. If it is merely a duty to notify after the fact, it would seem to Your Honor, that greatly reduces the benefit of the consultation regime. It's almost meaningless. And
I'm not sure that she said she said notify, but I don't know that she intended notification after the fact. But you would concede, are you conceding that there's no obligation to consult with an affected or a potentially affected producer in the market?
No, I'm not, Your Honor. We maintain a position that is a duty to consult with both. But I was just addressing the specific point about consult with CARICOM. And if I may just respond to something Your Honor just said. The difference between notify and consult, my respectful submission, is in large part when you do it. You consult before and you notify after. Because if you're telling me before, you're effectively consulting with me. So that's why I interpreted notify to mean.
I see.
Post.
There seems to be some leeway in CARICOM's position, where I noted it was repeatedly stated there is no practice of doing it.
Yes. Well, one thing I did think, Your Honor, is that a great benefit that may come of the parties have invited CARICOM to take part here and to make these submissions, is that we may all get some guidance from the court.
Yes, of course, to the extent that these are policy decisions, I mean, to the extent that they are, the question is what's the locus for making those decisions, And because there has to be a difference between clarifying and policy making. And I would have thought policy making should reside somewhere else, but that's another point. Do you have any response to her views on the question of quality, regional standards and so on? Because again, she seems to be suggesting that the manufacturer in the member state has some leeway.
The problem with that, Your Honor, so we came back to the question. There's a question that I think the President had asked earlier about the difference between specification and quality. So it's one thing to say that manufacturers may have different specifications. I think it's an entirely different thing to say that manufacturers can determine what is an appropriate level of quality. Because that then is necessarily subjective.
Yeah.
That necessarily varies from manufacturer to manufacturer. And we were concerned earlier about different states having different policies. That then descends to an even more unworkable level, if I'm respectfully say so. So
So you have no difficulty if the manufacturer has objective technical standards, which are out there, and which we can know if they're met or not. What you object to is something different, more, blurry issue of quality.
And this case raises the kind of things that would be cause concern.
Yes.
The smell.
Yes.
That ought not to be something that each manufacturer can say, oh, I don't like the smell.
Thank you, sir.
Thank you, Your Honor.
Yeah, okay. Well, thank you very much, Counsel, for your assistance in this matter. Jamaica, you want to say something? No, I didn't think so. Oh, okay. I did have a right to reply. Naturally, we would reserve our decision and would let you know. Of course, there has been a concession on an aspect of liability, and so in all probability, we'll have to, not in all probability, we will have to have another phase of this to see what relief, and in particular, whether the relief that has been claimed is substantiated. And so when we give our judgment, our ruling, or decision in this phase of the proceedings, the likelihood is that we will either give a sort of timetabling for the future course of the matter, or convene a case management conference to have a discussion on that future course. But in any event, you would know. Madam Registrar, could you please adjourn the proceedings?
Evening's proceedings are adjourned.
All right.